Gitanjali at premises number 8B Middleton Street, Kolkata, 7,16,000, and ascertain as to who is in possession of the said flat and in what capacity if the purpose is occupying, and such inspection shall be carried out upon notice to the applicants and the learned advocate for the defendant number 4. Learned special officer shall be entitled to so and so. Let this matter appear on 7/7/2025 for report of the special officer and further orders. So your A and C is allowed,
Well,
and B and other further orders subject to the report of the special officer.
I'm deeply obliged.
My lord, I appear for the plaintiff, my lord.
Okay, your name will be recorded.
I am appearing for defendant number 5 and 6.
Give your names.
Dichi, Dichi.
Item number 2.
Grateful, my lord.
Yeah, this matter was heard. So now the question is, in this matter, did you file written notes of arguments? No, I know, I heard the
I
matter.
will give written notes. My lordship, so far lordship's query was regarding GST. Lordship rightly put to us, and I had said that GST either they can pay directly, we'll give the amount, or we shall pay and then they'll reimburse.
So that is the procedure. Question is with regard to GST and other points of law, did both sides file written notes? That is
No, we can file it by
Friday?
Yes.
by Monday.
Next Monday? Yes, record an order. Learned advocates for the parties are present. Let written notes of arguments be filed by 23/6/2025, 23rd. Let this matter appear for orders on 30/6/2025. So file your written notes and clarify it by 23rd, and I shall pass the orders on 30th.
To be mentioned, item number 3.
সাড়ে বারোটায় হবে এটা, সাড়ে বারোটায় কল হবে।
New motions, item number 4.
Yes, pass over.
Item number 5.
Wait, please, your lordship, I am for defendant number 1A and 1B.
Dependent number, you are for?
1A and 1B, my lord.
Today is fixed for report of special officer.
No.
Respondent number 4A.
My lord, I am respondent number, substituted respondent number 3A.
আগের অর্ডারটা দেখি। Oh, the records has not come. Let it be not today.
My lord, on the last occasion, my lord, I had handed over my copy to the learned court officer. As far as GA18
the other record, the orders and other records are necessary. So it's better I make it not today.
My lord, otherwise GA, the next matter
Not
is,
today and not tomorrow. That is, I shall keep it on Wednesday.
my lord, as far as GA18 is concerned, that is item number 5. And item number 6, my lord, is my
Item 6 এর record আছে? So item 6 records are here. Item 5 records are not here.
my lord, item number 6 is also my application. On
Let it
behalf-
appear tomorrow, day after tomorrow, along with both the matters.
My lord, both are technically identical matters, but the only difficulty is it's a partition suit which is going on since 1992. My lord, there are several defendants, my lord, who are quite aged, and many of them has passed away during the course of hearing and all, for which several substitution was done over.
No, I shall take it up. Entire all the applications will be taken up for consideration. So, এটা রেকর্ডটা কি চলে আসবে দুদিনের মধ্যে, 5-6 তারিখের মধ্যে? হ্যাঁ 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 রেজিস্ট্রারকে তাহলে আমি দিয়ে দিই।
কত নম্বরে? 5
আচ্ছা,
5-6 রিপোর্টটা নেবেন না?
It's better you file it on the next date because the records are not here. I'm just directing the matter to be appear after 1 week. Yes, record an order. Learned advocates for the parties and learned special officer are present. As records of GA18 of 2023 is not here, this matter stands adjourned till 23/6/2025. Register original site is requested to see that the records are put up on the next day. That is on 23/6/2025. Yes, item number 6. Let this matter appear on 23/6/2025. Both 5 and 6.
Item number 7.
Item 5 না এটা item 5 এ বললাম, item 6 হলো let this matter appear on 23/6/2025. ব্যাস এইটুকু। Yes, item 7.
Item number 9.
Yes, pass over.
Item number 10.
Nine, I was appearing, my lord.
Yes,
My lord, the display board is not working. That's why, my lord.
My lord, item number 9, my lord, I was appearing, my lord, virtually.
yes, item 9. Anybody? Yes.
My lord,
Appearing for the plaintiff in this matter, Mr.
You are for
Ghosh.
plaintiff. Yes, Mr. Datto, you are appearing for?
I am appearing for the, my lord, defendant, the applicant. This is that application by which, my lord, we are seeking, my lord, an order for production of a document from the office of the registrar of companies. Lordship was pleased to hear Mr. Shakushen on this application.
That has to be heard out.
No, my lord, it has not completely heard out. Mr.
No,
Ghosh
hearing
has
is
been-
not yet concluded.
No, my
There
lord.
is Mr. Ghosh has concluded reply arguments. Now we are to only rejoin, my lord.
Oh, when can Mr. Sen come ready?
my lord,
Mr. Ghosh has not
Mr.
completed.
Sen is otherwise ready, my lord.
Paying for a short passover. He is on legs before courtroom number 40.
Yes, what do you say?
My lord, if
Are
it is a passover, I don't mind. We are also ready, my lord. Lordship will kindly pass it over and take it up, my lord, when Mr. Ghosh is.
Grateful, my lord.
Item number 10.
For the plaintiff. The suit for partition and lordship, this matter was dismissed for default on
It is
30th
GA
November.
2.
GA 5 and 6,
No, this item number 9.
10,
Item number
10
10,
and 11.
10 and 11.
Right.
GA 5 and 6 are your application.
Yes, lordship.
Let me see. Have you served?
Yes, I have served the defendant number 2A. Already 2 has died and his substitution has been made. 2A has received and the 4 has returned back. This
No,
has
this is application for what? This is
application.
GA 5 is for?
GA 5 is for condonation of delay
Yes.
and 6 is for restoration of the application suit.
Delay of how many days? 500 days.
500 days.
Yes, where is the notice of motion?
Notice of motion, lordship, yes.
Notice of motion to dekhi. Notice of motion.
No, it was filed.
No, where is the notice of motion?
Notice of motion I have filed.
Where is that?
Right now, it is not, I have filed in the department.
The call. When did you file it?
We have only the Xerox copy. डेटটা দেখুন This is my office copy I have and the original has been filed in the department. It has not been tagged, most probably.
No.
This is GA6.
GA6 is restoration.
Notice of motion of GA5. GA5. Where is the notice of motion of GA5?
GA5.
Let me see your GA, this thing. GA6. In
Probably I have to check.
GA6, which paragraph you have stated?
Restoration lordship.
Yes.
The initial stage lordship, when the matter was dismissed, prior to that, it was while it was substituted for the defendant number 2, that since prior to that period, that is from the 2020, the plaintiff was suffering from various ailments and she has not in a position to contact with the lawyer because of her different disease. She was admitted several times in hospital and nursing homes on various type of reason. Along with that, the husband of the plaintiff, who was also a practicing advocate of this honorable court, and he was also suffering from that aspect. And since the COVID-19, they were suffering a lot. So in that manner, it was going on. So their main difficulties was that they were not able to keep themselves fit for contact with the learned advocate, and the matter was initially pending before the department for a round of some necessary rectification or any other matters. So in that circumstances, lordship, the proper remedy was initially taken in the year 2022 after passing the order. Thereafter, they were not able to keep contact. And even though since 23.
But I'm for the respondent number 1, my lord.
Oh,
Defendant
it is,
number
sir.
1, my lord.
Yes, you have been served with a copy.
Yes, my client has been served. My client is in deathbed.
Yes.
He is in deathbed. He is in deathbed.
No, question is this a restoration application? This matter is not decided on merit. So,
Yes, my lord,
so
your
you
lordship,
consider this petition and
but
you argue the matter.
kindly give me a 2 day, 3 days time. I could not get the copy, but he could inform me over telephone that they have been served.
You have served him a copy.
Yes, they
You
have
can
served
serve
me.
him a copy and I can keep it day after tomorrow.
Yes, lordship, I will serve.
Serve him, I'm making it not today and tomorrow.
Lordship.
And you ascertain regarding the notice of motion.
Yes, I will also ask.
Wednesday it will appear.
Witnessed.
New application, item number 12.
Lordship, my application, my lord. This is an application for discharge of the administrator, one of the joint administrator. On the last occasion, my lord has directed to suggest some names, my lord. Last order take to judge. 11 June. 11 June. Any.
Yes, you are requested to give further suggestion.
Yes, lordship. My lord, as per my instruction, my lord, I am suggesting the name of Mr. Defendant number 1A Roman 2, my lord. Obhijit De, and my lord, the Dulal Chandra De, and Shamsundar De, he is also a party. He can also take over the charge.
Advantage.
ঠিক আছে,
How can I take it? Why your
Lordship will kindly consider the name of
why your client is not fetching? What is the
kindly
reason behind it?
kindly take the name of defendant number 1A Roman 2.
Record.
Document. Lordship is you know it is very well. He's my nephew.
Yes. You are suggesting defendant number
Defendant
1A.
number 1A Roman 2.
Abhijit De.
Yes, Lordship. I am not there.
The other administrator who is continuing is who?
Is Gautam De, my lord, the next one
One is Gautam De, another
Gautam De is continuing.
is the administrator who wants
No,
to
at present, who are the administrators?
my lord, defendant number 2,
Defendant number
two.
Saurabh De.
Saurabh De.
De and Gautam De are present administrators.
Lordship.
So, defendant number 1B, 1B1 Gautam De has sought for discharge.
Lordship.
Okay. এটা কোথায় নোটিস অফ মোশনটা? Yes, record and order. Learned advocate for the petitioner, Sri Gautam De, is present. Heard learned advocate for the petitioner. The petitioner, Sri Gautam De, who is one of the administrator of the Devattar estate of Sri Sri Lakshmi Janardhan Thakur, has sought for discharge in this matter, and however has sought permission to retain his status of a Shebai.
Page 73, Lordship. I have written to the committee.
The page
Page 73.
Page 17.
73, Lordship.
73. Okay.
I have written to the committee for
learned advocate for the petitioner also draws attention to the letter issued by Gautam De, who is one of the joint administrator, to the committee of Lakshmi Janardhan Mandir Committee, situated at Fort Sri Ramchand De Street, Jagodal, Kolkata 151. Learned advocate for the petitioner in terms of the earlier order, and upon taking necessary instruction and making necessary inquiry, has suggested the name of defendant number 1A2, or namely Abhijit De, to be appointed in place and stead of Gautam De. The defendant number 2 herein, defendant number
along with defendant number 2.
Has sought be substituted in place and state of defendant number 1B1 Gautam De. Upon hearing the learned advocates and considering the grounds furnished, this court is of the view that the prayer of the petitioner should be allowed. Thus, Sri Gautam De, defendant number 1B within bracket clause 1, is discharged from the post of administrator. However, discharged from the post of administrator, and Sri Saurabh De.
Saurabh De is already at
okay, and Sri Abhijit De, defendant number 1A in bracket 2, is appointed as one of the administrator in place and state of Sri Gautam De. Stop.
I will continue as a Shebai.
Let there be an order in terms of prayer A of the notice of motion dated 29th March 2025. Let Abhijit De take over the charge of joint administrator from Gautam De.
I will hand over all the documents, whatever I have, my lord, to the
The
incoming
documents be handed over
lordship.
to the incoming administrator. Let a copy of this order be communicated to the parties as well as the receiver.
Lordship.
My lord, on my submission, the receiver has not yet been appointed.
Receiver is already appointed. You see the last order.
Yes.
11 June order, you please see. Receiver is already appointed.
ডিক্লাইন করেছে।
হ্যাঁ হ্যাঁ এই দেখুন আপনার নামে আছে শামসুন্দর মুখার্জি।
Action motion, item number 13.
Paying for not this lawsuit,
Yes.
not this.
Item 13, you are for?
I am for the defendant.
Okay. On the prayer of the learned advocate for the defendant, the matter stands adjourned till 23/6/2025.
Item number 14.
My lord, I am appearing for the plaintiffs, my lord, in this matter.
Receiver, my lord.
We are also the joint receiver, my lord.
Joint commission. My lord, joint special officer.
So which GA is to be taken up?
My lord, I'll explain what.
Yes.
There are.
Short password, my lord. I am getting for the 4A and 4B, my lord. Is coming.
Okay,
No,
short
let him come.
password.
Let him come.
My lord, there is
Yes,
something very hanky-panky going on here. Kindly permit me, my lord.
My lord, before
are-
that, before
Yes,
your
yes.
submissions, my lord, I am filing my affidavits of declaration, my lord, stating that I have served the copy to all the parties, my lord, except the yes, I am handing over. My lord, I am seeking for that Pradut Borua, one of the defendants here, my lord. I am for the plaintiff. We have given our authority to him to continue, but we will represent the before the plaintiffs. But
No, which application is to be taken up now?
my lord, today
Prior to that, my lord,
No
Yes.
on last occasion, we have submitted that, my lord, one Procedural over has
One plaintiff died.
plaintiff number 3.
Yes, do you have any instruction with regard to that?
Has to be, my lord.
my lord, yes,
Do you
my
have any instruction with regard to death of one of the plaintiffs?
my lord, one of the plaintiff, my lord, died. I have got the death certificate recently, my lord.
Yes.
The necessary step will be taken in the meantime, my lord.
So take
Because
necessary steps.
it is a partition suit, my lord. I will take the step.
Yes.
That is the first.
Take necessary steps.
My lord, yes,
taken
yes,
up
yes.
I'm adjourning
That ought to be. But any party can do it, my lord, because it's a
Whatever
partition
it
suit.
is your
My lord, carriage
prerogative.
of proceeding me, my lord. I understand, my lord.
So I'm granting you liberty to take that step.
But before that, my lord, today is fixed for that calling for the records from the department to show that as regards to the existence of the preliminary decree, my lord. Whether that has come to your lordships or not, that should be ascertained, my lord.
Preliminary decree has already been passed.
Already passed, but the original is not missing, my lord. So far, the department is saying, but your lordship was pleased to direct the department to produce before your lordship today. My lord, whether it has come to your lordships for your inspection or not, I do not.
See the earlier order, আগের orderটা দেখান।
My lord, let them finish. I have substantial
Yes,
submissions.
I will also-
Let them finish. Kindly hear me out for 5 minutes.
My lord, unless the parties are not substituted, but it's the partition, it's a share. And that has to be, my lord, properly distributed.
No, that is at
No,
the
no,
stage of
that
the
is
show.
nothing to do.
That has got nothing to do with
It is admitted. Portion Kumar Borua's heirs will get their Portion Kumar share. That is admitted. My lord, it will not stall their old proceeding, my lord.
They cannot stop.
Yes.
This is an old trick that they've been
My
playing.
lord, with your lordship, kindly, my lord, I am handing over the copy of my affidavit of declaration to the other side. Defendant number 4A.
No, you see, on 19th April, prayer was made by learned commissioner of partition for extension of time by 3 months.
Yes.
Anyway.
Yes, that has been
the-
completed.
The learned commissioner was directed to do the needful.
Yes.
Anyway, that was 19th April 2024.
My lord, we have done that.
Matter appeared last on 8th May 2025. No, there was no such direction of the department
No,
to
my lord,
put
may I clarify?
Yes.
There was a direction at an earlier point of time before this. There's no doubt about that. We're all on. The preliminary decree was not traceable in the department. That's also a fact. And a report to that effect had come. A second opportunity was given to the registrar. See if you can obtain it. Without getting into the controversy, my lord, may I now submit?
the original preliminary decree may not be available with any party.
Yes.
May not be.
Certificate copy is there.
We have a photocopy of that.
Not certificate copy.
You have a certified?
No, no, I have no. You have not.
We have a photocopy of the certified copy. The records can be reconstructed. No difficulty.
Yes, yes.
There's no difficulty.
There's
So
a
that,
rule. Yes.
that chapter closes.
No, but where is the report that they are not traceable? Unless a
there is-
report comes,
There
I
is a
cannot
re-
say.
there is a report at an earlier point of time from the registrar.
এই আগের order আছে register কে দেবো।
I don't remember the date, my lord, but there is a report that has come. That was before Justice Shogota Mujumdar.
Before a code be there.
Oh, there is the report of the registrar that no copy of the preliminary decree. Yes.
That's right.
Yes, yes. Neither any preliminary decree dated 16/6/70 nor any entry is there in the ledger of 1960. However, there is a decree dated 28/8/1963.
Yes, my lord. That
drawn up.
That is the
That is the
preliminary decree.
preliminary decree.
That is the preliminary.
Drawn up order dated 28/8/1963 and terms of settlement filed on 28/8/1963. This is
That
the
is the
observation.
preliminary.
Yes.
So this has to be put up.
My lord, yes. That should be brought to your lordship, my lord. From the
This is one thing. And the other thing is one of the plaintiff died and you are to
yes,
take
that is
necessary-
that will be taken
That
care
is a
of, my lord.
procedural
Certainly.
aspect. My learned friend will do the necessary of
Yes.
it. No difficulty with that. Now, today what is happening, if your lordship sees, there are 4 GAs before your lordship. My learned friend has today handed over a copy of a supplementary affidavit, possibly
Declaration.
a declaration, which are also on record.
My lord, we have
He
stated
says-
in my declaration that we are not interested to proceed with the because all the has been disposed of, all the issues.
Coming to that. Now here is where the problem rises. My learned friend on the extreme says substitution.
Yes.
That has got nothing to do with the 4 applications before your lordship.
Yes.
Nothing at all. I'll explain each application. GA 18, which is there, it is an application that has been filed by my learned friend against the joint special officers or commissioners, asking them to stay their hand and not proceed with the commission work. Justice Shogota Mojumdar was very express and categorical. Sorry, that cannot be done. They will do their work. We have done that work. We've completed the work. We have filed our report. Nothing remains.
You are representing?
I am also a commissioner of partition, my lord, joint along with my learned friend and an external. My learned friend's counsel was also a joint commissioner of partition. He moved away. He sought leave of the court. He said, no, I don't want to be here. The reason being, because all these tricks are now being played. And I'm very express in my
How many
submission.
GAs are to be disposed? GA 18.
I'll explain, my lord. That GA 18 is one application which I just explained. Nothing remains in that application.
No, whose application is GA 18?
All 4 applications are his.
GA 18, 21,
23, 24. All 4 are his.
All 4 applications. To stall the proceeding.
That's right.
So all affidavits are complete.
Everything is complete.
My lord, my lord, copies,
So why? Why should they be remaining pending?
copies of the applications was not served on the plaintiff, my lord.
Then how have you filed the affidavit?
No, I have not filed the affidavit.
Did not file the affidavit.
I am not filed the
Why have you not served the application?
Yes. No. Plain. My lord, no, maybe, but the copy should be served either to me or to my client.
You should be not. I'm very clear. I'm making this.
Everything
submission-
is issues, my lord. The whatever they are doing, my lord, is beyond everything, my lord.
I am making a very conscious and a deliberate statement, my lord. This is a clear.
You want to move these applications?
Let him.
Any day, my lord.
No, my lord. There's nothing remaining in this.
No, but you also.
No, but my
He
lord.
does
So
that.
when
because-
can you take steps?
My lord, whatever submissions will be given by my learned friend, my lord.
Question is when can you take steps
For
to file the substitution application?
Substitution
Next week.
within 2 weeks.
Within 2 weeks.
My lord, within 2 weeks.
2 weeks time is required.
My lord,
Not really, my lord.
my lord, my
Okay.
lord,
Kindly hear us out, my lord. Kindly hear us out before.
my lord, kindly.
No, you see, you are the officers of the court. You do not have any
No, no,
interest
no.
in the.
We are also the council.
No, counsel for the parties and joint.
Yes.
My lord, kindly hear me also.
That is exactly why I'm asking your lordship for, kindly hear me out for a moment.
Yes.
My lord, we are the joint special officer. We are appointed as per court's direction.
As per the court.
We have discharged our duty. We have
Yes.
filed our report before the court.
Finished.
Though we have not accept our initial remuneration.
Nothing
we
has been
got
paid.
Nothing on the last occasion. My lord,
And plaintiff knows everything, my lord. That is okay.
that it will be considered on the next day. That is today, lordship. My lord, I am.
When did you last receive your remuneration?
Right at the initial stage.
Initial stage. After that, we will not get it.
Initial means which date?
About, my lord, I don't remember the date.
1 year, more than 1 year back.
It's almost about a
More
year and a
than
half
1
year
years
ago.
back, lordship.
Learned advocate for the
I am filing.
please.
I
Learned
think the
advocate
landed receiver has
for
got
the
the
plaintiffs. Learned advocate for
4A and 4B.
defendant number 4A and 4B. Learned advocate for
My lord, I'm filing my report. My lord,
learned
regarding-
advocate for the. You are for
My lord, we are for respective parties as well as the joint
which
company.
parties?
3A, 3B,
Learned
3C,
advocate for
3A1,
for defendant number 3A1,
3A2,
3A2,
3A3,
3A3,
3B and 3C.
3B, 3C, and
I
learned
have got
advocate.
all other defendants
And for all other defendants,
except my learned friends clients and 4A, 4B.
for other learned advocate for all other defendants and learned advocate for the receiver are present.
Yes.
Heard learned advocates for the parties as GA 18 of 2023, GA 21 of 2024, GA 23 of 2024, and GA 24 of 2024 are pending disposals. Let this matter appear on 36 2025. Stop. It is submitted by the learned advocate for the plaintiff that one of the plaintiff died, for which necessary steps are to be taken for substitution. The learned advocate is also granted liberty to take necessary steps for substitution. In the meantime, upon service of copies upon all the learned advocates. Stop. As the last remuneration of the learned special officers was paid 1 year ago, let a further remuneration.
My lord,
Yes.
My lord, that in that regard, we have to make some.
Yes. Yes.
My lord, just regard the status of the fund. I am filing the-
Just a minute.
On last occasion, directed the receiver to place the report. Yes, accordingly, he is filing his report.
He's filing his report.
Filed by the receiver, there is no common fund, my lord, lying.
No, well, that's wrong.
Only the fund which is lying, that is for the minor.
My lord, let me just explain. My lord, let me just explain what has
My lord,
happened.
that is incorrect.
No. The question is receivers are to be paid remuneration.
How can he say
Please,
that?
please. But
Let me just
yes. No, how can I compel them to work, go on continuing
Work
working
is
in this
finished.
way?
Done.
We have seen how long they will work without remuneration.
My lord,
You have to consider this aspect also.
my lord, let me just explain.
Yes, when did you last pay?
My lord, it was not it was not a payment from my instance.
No, by the parties, I think, shared by the
From the
parties.
front, from the front.
I'll indicate. Just give me 1 minute. Sir, my lord, there is a specific order. Well, there is a specific order of this court. My lord, let me just indicate because everything has not been forwarded and brought before this court. My lord, there is a specific order, my lord, on the last occasion. If your lordship just comes to the last order of your lordship,
Yes,
that 28th of April. 28th of April. Let me just take back your lordship to the records. Anything cannot just happen in a day. There are circumstances which must be brought to the court, my lord.
Which you have not, unfortunately.
Let me explain, sir. Let me just explain.
Application.
And they have not
for
got the
appointment of
records.
Joint,
And let me just explain.
joint commissioner.
And then they say that no, payment are not
after-
to be made.
On the basis of his application, order was passed. We started acting. We discharged our duties. We filed our report. While the report was kept on record, now he is saying
It's the last
it
order.
is unheard.
It-
The applicant is saying that
On his application, we were
it is
appointed.
unheard that the landed joint commissioner should not.
They should
Yes,
be
28th
apprehensive.
April 2025.
Yes, this is the order, your lordship. Your lordship kindly peruses the order once. What were the directions, set of directions? Learned advocate appearing for the defendant number 4A and 4B, and the learned advocate appearing for the defendant number 3A, 3B, 3A, 3B, 3C, and learned advocates appearing for the other defendants, along with learned advocate representing the receiver, are present.
learned advocate for the plaintiff is not present. This is very important. Now, as this is a very old suit, this court is of the view that the learned advocate for the plaintiff should be served upon notice.
Yes.
Now, Your Lordship, thus the matter stands adjourned till 16th of June 2025. Learned advocate for the defendants are requested to serve a notice upon the learned counsel for the plaintiff, intimating the order fixing the next date. Let a further remuneration of 700 GM be paid to the learned receiver. The learned receiver may appropriate the same from the fund which he is holding and submit a report before the about the present fund on the next date of hearing. With regard to the remuneration of the joint special officer, the matter will be taken up for consideration on the next date fixed. Let the learned registrar original site take steps to trace out the preliminary decree dated 6th of June 1970 and submit a report to that extent.
So regarding receivers remuneration that is paid,
my lord,
700, no, that was appropriate.
I'm just coming. I'm just coming, my lord. There is a
now the fund is held by the receiver.
Yes. And what is this fund? And what is this fund about? The receiver was being appointed. Let me just appraise the court. 1 minute I will take.
I shall hear from the receiver what is the amount available now.
If receiver would have been very fair before this court, my lord, I would not have been this problem. My learned friends also would have no problem.
Yes.
If the receiver could have ventilated the real cause and how he is holding this fund, what is this fund for? He's giving not a clear picture before this court. I can indicate it from his affidavit.
Several times.
I will just
when was the last payment made?
My last payment was made. There was a
joint commissioner.
Yes. No, joint commissioner, my lord, at the time of appointment.
When that is
2 years ago.
I mean,
please show that order.
I will. Well, there is a specific order where at the time of appointment of the learned joint commissioners for the purpose of this commission work, there was an ad hoc payment of rupees 50,000 made to each of the appointed commissioners. I was also appointed, was one of the commissioners.
Now you are no more discharging the fund.
No, yes, I have just retired because of my personal difficulties. Now, at this point of time, what are the orders, my lord, that is to be taken care of? Because coordinate courts have also passed orders in connection with this matter. There are 4 G applications which are before your lordship today. We must not be taken away like this on the basis of mere submissions. There are affidavits that are being exchanged between the parties with regard to these applications, which are to be heard out by your lordship.
No,
now, if I just indicate,
are for what?
Yes, there are 4 sets of
applications will be heard out. Okay.
Yes, but
now I am asking you, when did you pay the last remuneration?
The receiver was being paid. It is, my lord. I am not the person to make the payment, but the receiver is holding the funds.
Receiver is holding. How much fund you are holding now?
My lord, that is the problem.
Yes.
Now, what is being indicated by my lord?
Now give a statement regarding under what heading you are holding the funds.
Yes. What is the capacity?
No. From which fund the commissioners were last paid?
Let me just indicate one thing. Now the receiver was being appointed for the purpose of auction. Yes. Now there were gold coins and a hookah belonging to Maharaja Jahangir. Well, for that particular purpose, the receiver was being appointed at that point of time in 2015. Now the gold coins of East India Company have been auctioned, and the money and the highest bidder's money was being shared between the shareholders. Where between the shareholders, all the family heirs of Raja Prabhat Chandra Borua had their part in this auction bidding process, and they were being given this. Now, subsequently, the hookah was also being taken. An endeavor was being made by the Honorable High Court, my lord, to go for a private hookah auction. Now, that failed. And there were 3 successful participants who participated and deposited their earnest money before this Honorable Court. Now, ultimately, what happened is they failed in depositing their balance money of 25%, which they were required to put in. Now, the receiver is holding the personal funds of that is the earnest money of those successful bidders who participated at that point of time, but ultimately they failed. Now, there was a specific bidding condition where if the parties fail to put in the balance consideration price within 48 hours from the time of putting in their earnest money, then that money will be forfeited. Now, that condition is there. Now, my question is, my lord, if the money that is these are all individual funds. These are all individual funds by private individuals who have put in this 2 lakh each. There were 3.
See, if these commissioners cannot be paid from that fund,
there has to be a common joint fund.
No. Parties has to pay the commissioners according to the shares.
You pay. I have no
doubt. Parties will pay from the shares.
Yes.
You pay.
Whatever it is, parties
if you're lost,
I will just record an order.
If I may just indicate this order to your lordship.
My learned friends. Milord, now just hold on. Your lordship will kindly hear me out for 2 minutes, Milord.
Let me just make my submissions.
No. Yes, just
your lordship kindly comes to this particular order of 21st of March I will
Yes.
then indicate another order, Your Lordship. Now, it is clarified by the order dated 5th of March.
Yes,
If I may come to my lord, 21st of March 2024 order.
Yes.
By Justice Mojumdar, my lord, second paragraph. It is clarified in the order. My lord, kindly note the G applications at the top.
Yes.
These are the applications which are pending before Your Lordship. It is clarified in the order dated 5th of March that the Commissioner of Partition shall continue to do their job in the meantime. Since general applications, these are very important ones, are pending,
Yes.
and issues relating to the funds are yet to be decided till the decisions are taken. Kindly mark these words, my lord.
Yes. Yes.
Commissioner of Partition should not raise any bill for the time being and bear their expenses themselves.
We have done so.
Yes. Then, man, next paragraph. Learned Counsel for the defendant number 4A and 4B further submits that a modification of the preliminary decree is needed in view of the death of the original plaintiff and the defendants, and the shares of the legal representative should be rearranged. After so long, after so many hearings, the Learned Counsel suddenly woke up to realize that shares are to be reallocated and redecided. This should not be allowed as a ploy to impede the work of the Partition Commissioner, but at the same time, please.
These sort of submissions are unheard of.
Then come. I'm reading an order, my lord.
Because the plaintiff died, original plaintiff died, so entire period.
Let me just complete the order. Let me just complete the order.
The law is being rewritten, my lord. Today the law is being rewritten.
His or her share will
Let me just complete the order. I'm reading an order.
Yes.
But at the same time, this is very important. Liberty is given to file appropriate applications in this respect. The Commissioner of Partition in their report shall state the movable and immovable properties and those which are not partiable and those which demand sale. Now, this was the specific order of the court, which is dated 21st of March 2024. Well, at that point of time, there were 4 applications which are also pending before Your Lordship today. Now, there cannot be, because there is no family joint fund at this point of time.
Okay.
And the plaintiffs and defendants
I've heard you on these.
Yes.
Please. Pending hearing of these applications, as the common fund cannot be disbursed, the commissioners should be further remunerations of the joint commissioners shall be shared by the parties in accordance with their shares. Stop. The commissioners, without prejudice to their rights, at this stage shall receive 300 GMs each to be shared equally by the parties.
In the meantime, my lord, kindly record it that I have served all the copies of it.
My lord, may I respectfully submit?
Affidavit of declaration, my lord, kindly record.
My lord, today I have been served with an application filed by my learned senior plaintiff.
Now, all your applications are to be moved on the next day. Okay.
Yes.
I have kept it on 30th.
One more thing, my lord. There was another order.
Of the application be served on me, my lord.
My lord, one more thing. My lord, one more thing. I'll just like to indicate. My lord, there is a situation. My lord, GA, I'll just indicate, because Mr. Pal Chaudhary is here after a very long time, and it is a real surprise for us. Now, the situation is, my lord, there is an order. There is an order of 6th of September. Kindly record this order.
So regarding what?
Your Lordship, kindly see this order, particular order. It had to be 6th of September. Din, এটা তাড়াতাড়ি হয়ে যাবে। Din, part of the record table.
ওটা থাকবে। This is order 6th September. Yes, which portion?
2023. Well, I'm just carrying one copy with me. That is the problem. It will record the same. Well, Your Lordship kindly sees what is being reflected in the second paragraph, if I'm not wrong, well. Second paragraph of the order.
Mr. Pal Chaudhary, yes.
Please.
Some problem was between my client and himself, my lord.
Anyway, he's not pressing this prayer now. It shall be considered.
Well, subsequently, man, I'm just appraising Your Lordship. One more thing. Can't be. I should not have, my lord, unless there is a direction of the court. My lord, Mr. Pal Chaudhary has already left the matter long back. Subsequently,
No.
Another lawyer.
No, this is
It was not
Okay.
officially
That
recorded.
No.
piece of the
Cannot be done.
applications which is sought to be moved on 30/6/2025.
Let him move those applications.
Be served upon the learned advocates for the parties who are appearing in this matter.
But I have taken,
No, for all the parties I made it.
kindly.
We have got.
Very well, if they have already served, no question.
Let him move
Not
those
served.
applications. We'll take it up.
My lord, this is, I'll just indicate one more thing, my lord. This is,
Kindly record that what affidavit of declaration to what I
Okay, the affidavit of declaration filed by the learned advocate for the plaintiff copy served upon the other learned advocates
Milord,
be kept with the record.
Milord, kindly hear me for just 1 minute. I'm not taking too much of your time.
Pass the order. There is no
No,
question.
I'm
of further
not.
hearing.
I'm not asking your lordship to change the order. I'm not at all. I am making this statement with a very clear and conscious mind, and I will show it on the next date, my lord. A clear fraud is being perpetuated on the court, and I will show the documents.
Okay, let this application be heard out. In the meantime, Mr. Chaudhary, you please take steps to file the substitution application. Do not delay this matter.
First of all, Mr. Chaudhary should come up with a vakalatnama. I
He-
believe
Take necessary steps.
It's already
he has not
there.
filed any vakalatnama in the meantime because
No,
my lord,
I'm
after
surprised.
this order,
The rest of the.
my lord, there are transposition applications.
No, no.
My lord, there are
With regard
transposition
to-
applications.
With regard to legal aids,
See
you
the
please,
cause list, lordship.
legal aids,
even
you please
today.
take steps early, at an early date,
Yes.
so that the matter is not linger.
I am surprised that these submissions are being made.
Because the plaintiffs are,
Kindly see
because
the
the
today's
plaintiffs
cause list.
are not appearing in this matter, we had to take out transposition applications.
Yes.
Those are pending.
I am also seeing you after a long time. Because
Yes.
on the last 2 or 3 occasions, you were not there.
And after Mr.
So
My lord, should not-
now,
Milord,
now there should be no more latches.
Absolutely.
my learned friend has raised the issue of Mr. Pal Chaudhary's vakalatnama.
my lord, today-
There are 2 applications which are filed at his behest without a vakalatnama. Let him show that.
my lord, may I
Let him show.
submit, lordship.
You talk of
Kindly
vakalatnama.
see that today's cause list. My lord, kindly see that today's,
Vakalatnama not filed.
my lord, kindly see that
Applications are
today's
filed.
cause list. Mr. Pal Chaudhary's name is still
Still appearing.
Still
Subsequently,
appearing all along.
You see, there should not be defect in the record,
No, there is no defect.
because you should not invite any controversy.
But after Mr. Pal Chaudhary,
Time and again that defendant 4 and 4G matter coming to the lordship.
Anyway, I shall hear. You
We-
see,
It's
those applications will be served upon you,
And
Okay,
this, Milord,
They should have.
and you
Item has been taken.
yes,
can't
yes.
be, we could not have.
No, please serve it upon. I made it clear.
Yes, I will.
And you do the needful, you make your necessary application from your side.
your lordship has passed the order that the remuneration shall be paid equally by all party. Milord, I am
To
suspect
be shared by the parties.
to be
Without,
shared.
without prejudice.
Milord,
Yes.
I am making a submission clearly. There will again be a problem on this, and the
Absolutely.
problem will come from my learned friends.
Well, there are legal heirs who have passed away in the meantime.
There you
We
are.
are required to
Your
substitute those.
lordship, the
There has to
intention
be
is very
rearrangement
clear,
of
Milord.
shares. There has to be rearrangement of shares.
Submit one thing, lordship.
As per the shares, I have made it clear.
My lord, may I respectfully
Correct.
submit. These remuneration should be paid through the.
For the
account of
time being,
landed
let it be
receiver.
paid.
Can't be, can't, my lord.
I have made
Please,
it, I
please hold
have
it.
directed, if necessary, I shall pass that order.
Can't you do that?
Holding
Because
personal
they will,
funds.
time and again, they have perpetuated a fraud, and I will show you.
Do not complicate matters,
The
okay?
application is.
No, no,
being
we are
taken on
not.
foot, Stall the remuneration of the landed.
On the
receiver.
one side,
This is unheard.
on the one side, my learned friend's client goes all over the country saying 993 is pending, don't do anything, stay your hand. But he takes no steps to have 993 heard out.
And
None
there-
whatsoever.
And my lord, in the garb of pendency of this, they are selling off properties across India.
He has sold it off.
We have to ventilate our.
He has sold it off.
Come with necessary applications. if they have
Absolutely.
done.
That is also.
They are selling out properties. They are alienating, creating third party
Okay,
interest.
okay.
and we are-
Can you see our report?
Okay,
Everything
come
will
on
be
the
clear.
next day. Yes,
This
come on
client
the
has
next
sold it off.
day. ঠিক আছে, next.
Item number
What are these?
15.
But after the petitioner, Mr. Shivshankar Banerjee is appearing virtually, my lord.
Lordship, I appear for the defendant number 10, 11, and 12, my lord. I'm praying for a short passover, my lord.
15, who's
My
the
lord, every day this is going on, my lord. Kindly consider this. This is judgment upon admission, my lord.
My senior is appearing virtual, my lord. Mr. Shivshankar Banerjee.
PS6 is your
6,
application.
7, both my option.
In that case, lordship, kindly keep it tomorrow so that kindly make it not today if they want, but otherwise, lordship, please.
Matter dispose হলো না ওইটা হ্যাঁ ওটা dispose. Yes, so I'm making it not today, please come ready tomorrow.
Just a short.
Yes, ma'am. Yes, ma'am.
Giving any passover. Yes,
My lord,
you are ready?
I am for the 10 for 12, 10 and 12. And the applicant is
He has left, my lord.
Yes.
My senior left just now. Lordship told Passover. she left.
Okay, not today.
আরে উনি বললেন বলে বেরিয়ে গেল লাইন থেকে না
Huh? Passover করে রেখে দিও।
না ওই পাশে হয়নি
Passover matter, new motion, item number 4.
Okay, not today. Item 4 you are appearing.
Yes.
Oh.
Showing Ghosh?
Yes.
Yes,
Item
Your Lord.
4.
Yes, Your Lord.
Yes.
My Lord, this is an application in respect of a Devottar property, my Lord. Brief Tadish. In respect of a Devottar property, where in a suit, a decree was passed and a scheme was framed creating this Devottar property. My Lord, in the said decree, there has been a provision that if there are any difficulties later on, the decree was passed long time back in 1957. If there were problems in respect of running the Devottar estate, applications to be made before the Honorable Court for clearing out all doubts. Now, my lord, this Devottar property had large chunks of land. So from long time back, because there were tenants and the tenants were paying very low rents, applications were made for sale of parts and portions of the properties that were under the Devottar estate. This is one of such application in which we are praying for sale of a particular land, my lord. My lord, if your lordship shall come to the decree, my lord.
Yes, Annexure A.
Yes, your lordship.
April 9 to 1959.
1959. Your lordship, at page 23, running page 23, if your lordship comes to running page 23.
Yes.
My lord, there, the shares of the parties were declared. And in the shares
This
of
is
the
a Devottar property.
lordship.
So Devottar property means where is the scope? Any shares? Where is the scope
My
of
lord,
shares?
in respect of the Shebaiteship, my lord.
Okay, Shebaiteship.
Right. Yes, your lordship. If your lordship comes to a little later stage of that page, and it is further declared, your lordship has got it. Around the later half of the page, where the shares of the parties are declared. And it is further declared that the defendants Nolinakko Bose, Shailendra Shekhar Bose, and Achalandra Shekhar Bose are entitled to 4 annas share in the Shebaiteship of the DT. And the plaintiffs and her heirs and successors are entitled to 3 annas share therein. And the defendant Promila Sundari Dotto and her heirs and successors are entitled to 3 annas share in the Shebaiteship of the DT. Then comes Khagendranath Sen, then comes Pratul Chandra De and Purna Chandra De, and their heirs and successors. Now, over the years, what has happened, your lordship, that these persons, they passed away, and their heirs, in terms of the decree, they were substituted in the suit. Now, if your lordship would
Substituted as Shebaites.
Shebite,
As per the scheme.
as per the scheme, and in the scheme, if your lordship comes to if your lordship comes to page 24, the very next page, the last 2 lines. And it is further ordered and decreed that the parties will be at liberty to apply to this court from time to time when they may have occasion. So liberty was granted to the parties, that is the Shebites, to apply before the court for any problem that would arise in respect of running or governance of the Devottar estate. Now, if your lordship shall kindly come to the application, my lord. Your lordship shall kindly come to page 9 of the application, running page 9 of the application.
Yes.
This is in respect of the property we are applying before the court for sale, my lord.
So situated at where?
Situated at 70 by 2B, Gauribari Lane, North Kolkata, near Ultodanga, my lord.
That is Khanna.
Yes, that's right. So, your lordship, from the property, it appears that we are getting a monthly rent of rupees 26.25 per month.
The table 1.
That's table 1. So the yearly income from the annual property is just rupees 315. This does not cover anything, Your Lordship, in respect of the expenses, which is table 2. This is the annual expenses. More or less, there are other annual expenses which is added on by the Shebaites to run the estate. Now, Your Lordship, in the decree, it has been very specifically said that these 5 groups of Shebaites that have been specified in the decree, they have been allotted different pieces of land from which the income of those lands, the estate had to be run. And if Your Lordship kindly take up the map, and if Your Lordship kindly come to the scheme. Our property is situated, Your Lordship comes to running page 31. Today, this application is being made by the heirs of Pratul Chandra De and Punno Chandra De. It's 4, Roman 5 at the end of the page.
Page 31.
Page 31.
See, in this particular scheme or in the decree, there was a direction and guidelines of earning the revenue, utilizing the land so that it can fetch revenue.
Right.
But it is not specific with regard to the right to sale or lease.
Your Lordship,
that is only whether any liberty was granted, that in case of exigency, that is usually not done. On earlier days, usually it was not thought of that the Devattur properties will be sold.
And Your Lordship, the expenses earlier days, the expenses were, Your Lordship,
But
nobody
you see,
could
So
assimilate.
it was not necessary to make provision of such.
That is why, Your Lordship, this liberty was given to come up again if there is any difficulty.
Any exigency.
Any
exceptional circumstances.
This is an exceptional circumstance.
And for the purpose of the benefit of the Devattur
For the purpose of the benefit. And Your Lordship, another thing, we have made this, in this Devattur estate, all the parties have made several applications, starting from Your Lordship, the orders have been passed for by
prior to independence. The suit was instituted.
Yes, thereafter, even post-independence, orders have been passed by Honorable Justice Podda Kastugir. Till date, there have been more than 30 to 40 orders passed in respect of different pieces of
Anyway,
land.
you have links, relevant orders, I believe, in this petition.
Yes,
Relevant
Your
orders.
Lordship, relevant orders. And if Your Lordship, there have been orders annexed here, and there are various orders also. It would pile up to something very
You see,
big.
that is why you see in the earlier days, it was not thought of that.
Yes, Your Lordship.
It was not contemplated that Devattur property had to be leased out or sold. Only guidelines to utilize it for the purpose of income, let out or collect rent and so on.
And also liberty was granted that in future, if any difficulty happens.
Exigency.
So Your Lordship can understand.
Because you see that is the maxim that once a Devattur, always a Devattur.
Yes,
so
Your Lordship.
Devattur properties should not be sold. That is
Right.
that was originally the maxim. But
And
you see,
that is why
sometimes
orders have been subsequently passed. A whole lot of orders have been subsequently passed for sale of different parts and portions by different Shebaites.
Anyway, of the vacant lands.
Of the vacant lands, there have been tenants. No land is vacant. There are houses, there are tenants there. And it was actually from the earnings.
Yes, exigency means if there are no other alternative to earn income and to protect the Devattur property, then the long-term lease or sale, that is inevitable.
Yes,
that
Your
is an exigency.
And that is why we have made this application. And if Your Lordship shall see, we have got an offer from one of the developers, promoters.
Page?
Page 55.
Yes.
to sell a portion of land,
area 2 kathas,
2 kathas, 15 chataks.
vacant land.
No, Your Lordship, there is a tenant. I just showed you a
There's a
list.
structure building.
Yes, and the tenant is paying 315 rupees per annum. And from so this is the land which is
No, piece and parcel of land. You have not given this tag number and khotiyan number and all this.
Your Lordship, in Kolkata, there cannot be any DAG number. It has premises number. It's under the Kolkata Municipal Corporation.
Yes, yes, but this anyway particulars.
And there is always also in house. So the DAG number, khotiyan number cannot be there because it is mutated with the Kolkata Municipal Corporation. It's in respect of premises numbers.
Premises and this ward.
Premises,
number.
ward. So, and all these are given. Ward number 12, under police station, Bottola.
So the area is
2 kathas, 15 chitaks, and 30 square feet.
okay. And what is the proposal given?
And the proposal is for purchase of the land.
But the long term, 99 years lease. Absolute outright sell.
Outright sell. Your Lordship, there have been several orders before this also. A whole lot of orders for sale of such property.
Some of the cases you see the prospective parties are coming with a long-term lease that is 99 years or something.
No, Your Lordship, this is for sale. And sale orders have also been passed. There are, I can hand over orders to Your Lordship where.
So they have issued an offer letter.
Yes, Your Lordship. And in respect of that offer letter, we accepted the offer letter because
subject to the order of this court.
Subject to the order of this court. Your Lordship shall kind.
And what will be the mode of payment? At a time, 25 lakh.
At a time, 25 lakhs. Your Lordship shall kindly come to the prayer.
Yes, page 56.
Page 56. Yes, this is how the mode of the payment shall be made. That is, 9 lakhs have been paid. 6 lakhs shall be paid upon obtaining the order, and 10 lakhs more upon registering the deed of conveyance or the development agreement.
Usually, what is the market value of such type of lands? Anyway,
my lord, actually, there is no market value in respect of these types of land because there are it's fully tenanted.
No, maybe.
And
but
tenant is there for a long time.
If you measure it by a registered value, or how much it will be? About not less than 50 lakhs.
Your Lordship, nowhere near. Hardly people would pay even 5 lakhs. Because even if one buys it for 50 lakhs, one has to have that infrastructure to evacuate the tenants and then use that property. So nobody would be spending that amount of money and wasting so much of time. And Your Lordship shall knows how difficult it would be to evacuate a tenant who is there for more than 50, 60 years.
Otherwise, it can be mere vacant land can be 1 crore also.
Yes, Your Lordship. No, 1 crore. Yes, 50.
Unencumbered and vacant land?
It can be.
1
but
crore.
This is fully encumbered. And that too in a narrow strip of road, Gauribari Lane. So Your Lordship shall kindly come to page 16. Actually, Your Lordship shall kindly come to page 15, where we have prayed. Your Lordship shall see the offer to develop the said property in terms of the said offer letter dated February 4, 2022 be accepted on the terms and
page 50.
15, 1-5.
Oh, 1-5. Yes.
The offer to develop the said property in terms of the said offer letter dated February 4th, 2022 be accepted on the terms and conditions as contained therein and or on such terms and conditions as shall be deemed fit and proper. Leave be granted to your develop and or promote all the property 2 katas 15 chitaks by Mrs. Ram Construction, a partnership firm. And we have also said to invest the balance amount of the consideration money available out of the sale or disposal of the said DT's allocation, the whole or any part or portion thereof, after disbursement of the amounts made in prayer E, in fixed deposit. Prayer E is for disbursing the amounts required for this.
Because it is the purchaser who is to pay the stamp duties and the registration charges.
Yes, Your Lordship, but these court expenses are there, and there have been other expenses as well. So after disbursement of them, all amounts to be deposited in the name of the DT.
In a fixed deposit.
In a fixed deposit. And there is already an account of the DT.
You are representing the.
I am representing the petitioner. Actually, today I am representing the petitioner, Srimati Sriporna Mitro, Probir Kumar De, and Srimati Srilata De.
Capital A, 1.
2, capital 2A and capital 2A, 1. I. Your Lordship, Mr. Banerjee is appearing in this matter. So you'll
I've come at the right time, my lord, where I don't have to trouble your lordship too much. Your lordship would have been shown, my lord, previous such orders have been passed. The shares are delineated. The scheme has been framed by the court. This is for the necessity of the
I
deed.
was asking what is your learned junior, that what is the market rate? At least 50 lakhs.
It would be, but
Maybe 50 lakhs,
but
or even if it is a vacant land, 1 crore.
But the problem is, your lordship would have noticed from the other orders that these are all heavily tenanted. In each property there. So I may not fetch but the best price that we are getting, we're trying to. But this is absolute. People who are paying 60 rupees, 70 rupees were all there.
And it is a one time. That is at the time of execution of the deed, not that phase wise.
No, at the one. But whoever wants to give her money will have to make some kind of an arrangement. So we'll get a.
So this
The
offer
offer
letter
letter
was
is here.
accepted by you, subject to the leave of the court.
Yes, naturally, because your lordships have framed the
That means
scheme.
even if a court is passed granting you leave, a date has to be fixed for furnishing the draft copy of the. If there is an agreement.
Your lordship will grant me the leave to enter into this agreement and keeps it after. Give me the leave to sell the property.
But they have said advance amount so and so at
That's
the
right.
time
So
of
I
agreement.
will take that amount and get into the agreement with them. And that's why the leave is sought for, like it has been done in all other cases in this matter. If there is a problem, then we come back. Otherwise, your lordship will just give me the liberty to deal with this property with this particular whoever
Not
offer.
agreement, enter sell.
That's right. To sell the property through agreement.
So sometimes if it is a case of lease, a date is fixed for submission of the draft copy.
No, I'm telling this.
Outright.
Get into outright conveyance. Then.
Okay, service was effected upon?
All the parties. Here this really not adversarial. Because your lordship would have been shown this is divided into 5 particular families. And mine is absolutely.
Families.
That's right. And completely delineated, identified portion.
And it has been told in the decree that nobody is
correct.
Get into the shares of the others.
Mr. Banerjee, learned advocate for the petitioner is present. Heard. Learned advocate for the petitioner. None appears for the other parties in spite of service of notice. Hearing of this application. GA 60 of 2025 is concluded. Fix 26 2025 for passing orders. Yes, orders will be passed on 28th.
My lord.
Necessary orders. এটা একটু দিয়ে দেবেন এই ফাইলটার সাথে যে নোটিস অফ মোশন আর যেটা আছে এটা দিয়ে দেবেন.
Your lordship is making it returnable on the 20th.
No. Orders, final orders will be passed.
Oh, very well. Your lordship is reserving it for orders. Very well. Yes.
চেম্বারে পাঠিয়ে দেবেন ওর সাথে ওই যা এফিডেভিট অফ সার্ভিস নোটিস অফ মোশন যেগুলো আছে দিয়ে ফর অর্ডার্স বলে মেরে দিয়ে ওটাকে চেম্বারে পাঠিয়ে দেবেন.
Grateful.
Pass over matter item number 9.
I appear for the defendant.
In answer to that application, Mr.
You are for the
Sen's taken-
plaintiff. You are for the plaintiff.
I'm for the plaintiff. I'm sorry. I'm the respondent.
Application, my lord, your lordship had heard me, my Mr. Ghosh was. Lordship will recall, my lord, there is this document of emanating from the registrar of companies.
Affidavits are complete, so you are arguing that matter.
No, my learned friend completed. I have argued also substantially. I only had a judgment to cite. I'll give your lordship a short recap of the thing.
Your
I'll
Lordship,
give a
you can
note.
give because I shall give you few days time to file your written notes also.
Yes.
On the last occasion, probably I have told you to file the written notes.
No, I hadn't finished. So I had
Anyway,
to
you completed.
Yes.
The issue your lordship will just recall is the defamation suit.
Yes, that I.
Yes, so there is one document which is coming, emanating from register of companies. We had given them inspection, then it was found that one page is missing. So, my lord, we have said that let a subpoena be issued to the office of the register of companies to produce that document. This is not to say that the document is being admitted in evidence at this stage. Subpoena for production of the document. Then, my lord, the stage of evidence will come. My lord, probably my learned friend has no
Yes, you
real
are relying
objection.
upon a decision today.
So, my lord, all these submissions were made. I've dealt with that already. My contention is, my learned friends, the plinth, their whole defense rests on this foundation that there is a report filed, inspection report filed before the Register of Companies, on the basis of which they published this particular news item. Now, when in the plaint, they refer to this report. But in the list, I showed my lord the 3 provisions of the CPC. Under Order 8 Rule 1A, they are to mention the documents they rely on. They don't mention this document. Then many years later, that was in 2010, I think the suit was filed. Then when the issues were framed, and before that, when the affidavit of documents were filed, I showed that provision also. They don't rely on this document. Then the issues were framed and the witness is meant to come into the box. At that time, they take out this application. No, they give us a letter.
No, two issues, belated stage and the other is why this application should be allowed. Belated stage.
Yes, why it should not be allowed, because this is really aiding them to fish for evidence or fish out evidence. I'll show that judgment. Now, my objection was that they sent us a Xerox copy of the document they want to rely on, and they wanted to give us inspection. We pointed out this is an incomplete document. One page is missing. So now it turns out they don't have the original, or they don't have the full copy of the document with them, even at the time when they published the article. So that is a very important point. Otherwise, it's just a question of disclosing another document. I would not have stood in the way. But this is a very important admission by the defendant that they did not have this inspection report in full at the time when they made this application. Now, they wanted to rely on a photocopy. They are entitled to rely on a photocopy because they'll have to lead secondary evidence to do that. But now, at that stage, it struck them that no, we are going to apply and try and get the original document produced before my lord. Of course, what my learned friend is saying, I agree, that it will not become an exhibit automatically. They will have to prove it. They have to show it's a public document, or they'll have to call the relevant person and prove the document. That document is to come. But can that be done? If they can make a request to that person, then any other third person can bring a document to court. But does that need the blessings of the court? That's where I ended on the last occasion. Why should it have the blessings of the court? When you yourself are producing an incomplete photocopy on which your client has relied on, now you're trying to get the original document directly. And this document, other grounds, whether you can rely on this particular document or not, that, my lord, I'm leaving for arguments. Because it's an internal affairs of the company. It has nothing to do with the public records or any public officer. Be that as it may, I'll just complete. I'll give my note on the next occasion. I'll give the full note. And if I may just cite one decision, 1978, AIR 1978, Calcutta 296. No?
Yes.
Yes.
Yes. Want to go to the paragraph? The facts, at least what I am going to rely on, is in paragraph 3. my lord turns over to the second page. This is a division bench decision, but it relies on a famous Supreme Court decision.
Yes.
I'll cite that also. So Mr. Shoktinath Mukherjee, learned advocate appearing for the petitioners, contends that the said ex parte orders were per se illegal, inasmuch as there cannot be any commission for the purpose of fishing out evidence. This is the line that I want to use. Here they cannot, your lordship need not give a subpoena to fish out evidence. What they have to stand and fall on what they have. They have a photocopy. Let them prove that. Then, Mr. Mukherjee submitted that the subject matter of the suit was not the proxy form and the wrong counting of proxy forms may be an evidence favorable to the plaintiff, but it was not the duty of the court to help the plaintiff to fish out such evidence of wrongful counting of proxy votes by appointing a pleader commissioner for the purpose. Then Mr. Mukherjee submitted that Order 39, Rule 7 applies to the subject matter of the suit and not to any evidence in the suit. Also submitted that under Section 151, such commission could not be issued by the court because issue of an inventory commission for helping a party to fish out evidence is opposed to justice. In this connection, Mr. Mukherjee relied on the decision of the Supreme Court reported in Padam Sen versus State of UP in 1961 Supreme Court. It was held in the said case that if there is any allegation that certain documents are forged, the party can prove forgery by evidence. But it was not the business of the court to collect evidence on behalf for the party. Mr. Mukherjee submitted that even in case of interrogatories, it is an accepted principle that the interrogatories should not be prolix, oppressive, unnecessary, or scandalous, or such interrogatories should be allowed, nor such interrogatories should be allowed, which are intended for fishing out a case for the party. For this contention, Mr. Mukherjee relied on ILR 37 Bombay and also on the decision of 1958 Rajasthan, where it was held that under Order 39, Rule 7, it was not open to the court to seize certain documents for the purpose of use of the same as evidence in the case. So here also he is just wanting to show evidence. My learned friend made categorical submissions. Whatever they have broadcast is based on this report. So then the assumption is they had the report and they obviously appear to have a photocopy of the report, which is incomplete. So let them say that they relied on an incomplete document. My lords will not assist him to get the original document, and then we'll find out what is there in those missing pages. So it's for him to prove. That person must first go into the box and say that I got this copy, this photocopy, someone gave it to me. Even if it's a confidential document or not, we'll see in the plaint, in the hearing of the suit. But he can prove it in many other ways. This assistance of the court is not required. That is my main contention. Now, these were the submissions. Then, my lord, paragraph 6, not 6. Paragraph 5, my lord, the next page, just the conclusion. Yes. Of exercise. Yes, if my lord comes to the last page of the
para 5.
Yes, part of para 5 on the last page, just about 6 or 7 lines from the bottom. Your lordship will see there's 115 section 115 of CPC is referred to. Just the next sentence. The question of exercising discretion, however, does not arise in this case because we are of the view that an inventory commission cannot be issued for the purpose of fishing out some evidence which may be adduced by either parties in the suit. It is therefore improper exercise of jurisdiction of the court below, and such improper exercise had occasioned a material failure of justice. The rule, therefore, is made absolute, and therefore there is no order as to cause. So basically, the court does not ultimately assist them to collect or fish out evidence. And my lord, just for completeness, my lord, I'll just cite the Supreme Court decision referred to.
1961.
Yes. Now, AIR 1961, Supreme Court 218. Paragraph 9, my lord. Paragraph 9, just to give a bit of the history, I'll read the beginning, but not the portion I'm relying on. The question for determination is whether the impugned order of the additional Munsif appointing such and such commissioner for seizing the plaintiff's books of accounts can be said to be an order which is passed by the court in exercise of its inherent power. The inherent powers saved by 151 of the code are in respect of procedure to be followed by the court in deciding the cause before it. These powers are not powers over the substantive rights which the litigant possesses. Specific powers have to be conferred on the court for passing such orders which would affect the rights of the parties. Such powers cannot come within the scope of the inherent powers of the court in matters of procedure, which powers have their source in the court possessing all the essential powers to regulate its practice and procedure. Now, from here, my lord, it's important for me. A party has full rights over its books of account. The court has no inherent power forcibly to seize its property. If it does so, it invades the private rights of a party. Specific procedure is laid down in the code for getting relevant documents or books in court for the purpose of using them as evidence. A party is free to produce such documents or books in support of its case as may be relevant. A party can ask the help of the court to have produced in court by other party such documents as it would be used in evidence and are admitted by the parties to be in its possession. If a party does not produce documents it is lawfully called to produce, the court has the power to penalize it in accordance with the provisions of the code. The court has further power to draw any presumption against such party who does not produce the relevant document in its possession, especially after it has been summoned from it. Even in some cases, in such cases where the court summons a document from a party, the court has not given any power to hold the document forcibly from the possession of the defaulting party. The defendants had no rights to these books of accounts. They could not lay any claim to them. They applied for seizure of these books because they apprehended that the plaintiff might make such entries in the account books which go against the case they were setting up. The defendant's request really amounted to the court's collecting documentary evidence which the defendant considered to be in its favor at that point of time. So, my lord, if I may stop here, that here also the defendant has no right to that document. It's my internal inspection report which was lying with the Registrar of Companies. He has no right as such. So he, of course, can rely on that report as evidence because he has seen this report. So that secondary evidence he can give. But so this says he cannot request, his request now also amounted to the court collecting documentary evidence which he considers in his favor. That's my learned friend's clear argument that we relied on this document. This will show that I have reported the real facts and that's the end of the matter. That's basically it. That is his evidence. He has to prove that. If it appears that the report is not in accordance with what they published, then my case succeeds straight away. But it is for them to prove the document on their own ability.
First of all, whether it has a relevance or not.
Relevance it probably has. That will be decided.
And second is whether for this order of the court is required, or not.
Because they have a photocopy. They can give secondary evidence of that. If it was a public document, they could have got a certified copy. The suit is pending now for 15 years. The written state. Yes, well, paragraph 10, as the last line also is important. It is no business of the court to collect evidence for a party or even to protect the rival party from evil consequences of making forged entries in the books of accounts. And that is different. But it is not the business of the court to, why should they come to court? They want to rely on a document. They are out of time with it. That's number one. That's my first point. They have not followed the procedure, the court, as when they filed their written statement, they didn't annex the document. When they filed their affidavit of documents, they didn't disclose it. After issues, they purport to disclose a photocopy, which is admittedly incomplete. Now they want to produce the original to match it up. But that will be a different documentary evidence to show whether or not the one they had is an authenticated photocopy. That's the only relevance that original has. Because this court, nor in this suit, is it deciding what went wrong or what happened before the register of companies. We are only concerned with, could they have published an article based on this second-hand information that they allegedly had, and say that we are falsifying, fudging the accounts, etc. So it was quite a serious. Of course, after we got the injunction and after we wrote to them, they stopped doing it. But the suit remains. Well, that's why it's been here. It's been pending. I'll file a note and my learned friend can answer comprehensively.
Let
to
him
my note.
reply and conclude, and thereafter you file the notes.
Yes.
আমি একটা জাজমেন্ট কিন্তু ডিল করব হ্যাঁ But first is the point of delay which my learned friend is saying. But one thing my learned friend cannot dispute, my material defense rests on that document which is part of my pleading in the written statement. It is not a case where evidence is being sought to be laid towards the defense taken in the written statement. Express defense taken in the written statement is justification of the program which has been telecast. Program has been telecast on the basis of this report. Your Lordship has a look at my written statement. There is no other, this is specifically pleaded in the written statement.
Not annexed with this application separately.
Anyway, I have taken this point in your opposition.
Opposition.
That means in your petition.
In my petition, not only in my petition, what my learned friend is saying, that documents relied upon in the written statement, there I have not mentioned it. In affidavit of documents, I have not given this document.
It's a belated stage. The second question is, yes, relevance. The third is whether the court is empowered to pass this order.
Today's question is, today, Your Lordship will see my prayer. Issuance of subpoena. But for that, strictly speaking, even the court's order is not necessary. This is an application by way of abundant caution. And does not be, and there is no bar either in the Civil Procedure Code or under the original side rules regarding the summoning of a document, of a third party document from the authority where the document originated. There is no bar. Now, what is the crux of the objection? Crux of the objection is, I have not made it a part of my written statement. My lord, with the greatest of respect, in a suit which is not a commercial suit, there is no mandatory requirement or that the courts are powerless for production of document which is not mentioned as part of the written statement. That is why I say that it is not a case that my written statement, my defense is silent on this document. It is not a case. Then the question of objection could have been, how could I supplement my defense which is not there through another document? But probably that he cannot raise because my defense case rests on that document. I may not have annexed it. Annexing documents with the written statement.
But there is a mention.
Yes, my lord, that is what I want to show from the written statement, your lordship can see. And the written statement. Your lordship takes my on the last occasion, I placed my written statement also. Parts of it.
I also learned. My learned friend had shown paragraphs, pages 13 and 16, and I had shown page 12, paragraph 12, page 16.
Page 13, your lordship will straight away come. Last few lines. Answering defendants have merely reported violation of various provisions of the Companies Act by the plaintiff as mentioned in the inspection report of Deputy Director, Inspection, Register of Companies, Kolkata. By doing so, answering defendant have presented an unbiased, unmotivated story with a. So therefore, my defense is this document. Now, my lord, even if the document is not annexed, can I not produce the document? May I ask this question to myself? Then, my lord, the next thing which my learned friend says is that, so my lord, so my first point is that there is no prohibition either in the code or in the original side rules which will preclude a party from producing a document which is not annexed to the written statement or which is not shown as relied upon in the written statement. When in the body of the written statement it finds a mention. So once it finds a mention in the body, automatically the document is relied upon. That is number one. But also, same thing, even if I don't mention it in the affidavit of documents, I still have a right to seek the document and produce the document. Next point, my lord, is it is a third-party document. It is not a document of the other side also. It may happen in certain cases that I am relying upon some document of the other side. I give him a notice to produce. He does not produce. Then it is for the court to raise a adverse presumption. This is a case of a third-party document. Where it is a case of a third-party document, then I am trying to meet my learned friend's point of fishing out evidence. This is not a case, it cannot be equated with a case of a fishing out evidence. But that is a proposition we always use in some or the other to avoid
Commissioner cannot be appointed to fish out evidence. This is well settled.
That is a different thing altogether.
That is, your case is not, it is not application for appointment of commissioner to fish out evidence.
That. If that principle is applied, then a defendant or a plaintiff cannot even be required to give a notice to produce to the other party to produce a document. That will also amount to fish out evidence. So this fish out evidence, this concept and this phrase, I may say so with some respect, that it is a very elastic concept. Every party uses this phrase to their advantage whenever it suits them. Kindly consider the concept. When it is an usual concept that I give a notice to the other side, you produce this. Otherwise, court will raise a presumption. What does it mean? A relevant document, you are bound to produce it. So that will also amount to I am forcing another party an evidence which I don't have. I am trying to fish out evidence. That is not a case of fishing out evidence. Fishing out evidence is something which you are not sure whether it might help you or not. You are taking a chance that let me collect these things also. It might help my case, as it happened in this case. The defendant was trying to seize the books of accounts of the plaintiff so that the plaintiff does not commit any accounting manipulation regarding the account. So that's something in contemplation he is trying to do. That is something which is called a fishing out evidence. And here, my lord, when a concept of note, we have a document. I have a copy of a document of the plaintiff. And I know that I have made a statement that plaintiff has issued that document. Now I tell the plaintiff, give him notice that you produce it. That's not a question of fishing out evidence. Here also, my lord, I emphatically say that there exists a report. And I have telecast a program on the basis of the contents of that report. It is a third party report. It is not bound to be with me. I have all the rights to call for production of that report. This concept of fishing out evidence and getting documents collected from the source, this has undergone a sea change in our legal jurisprudence with the coming into effect of the Right to Information Act. This aspect has undergone a tremendous change. Today, your lordships do not question where have I got this document. Suppose I have a copy. I need not even have a copy. I need not even produce the document. It is sufficient for me to say there is some official document from where I have come to know that some illegalities are being perpetrated. The other side, in these situations, cannot even question that unless they can show that no document exists. So today, my lord, in today's legal jurisprudence, my lord, if I refer to a document and that document is produced,
So it is not a fishing out of evidence.
Cannot be a case of fishing out of evidence. And my lord, then my lord, my learned friend is relied upon. Kindly look, Order 8, Rule 1A, Sub Rule 3. First of all, my lord, kindly see Sub Rule 1. So Sub Rule 3 says document which ought to be produced in court by the defendant under
Order 1, Rule.
Order 8.
Order 8, Rule
1 capital A.
1 capital A.
Then Sub Rule 3.
Yes.
Sub Rule 3 says a document which ought to be produced in court by the defendant under this rule, but is not so produced, shall not, without leave of the court, be received in evidence on his behalf at the hearing of the suit. First of all, this rule will not apply because this production which I am seeking is not for the purpose of receiving it in evidence. It is only coming to be court to be produced. Evidence stage is later. Sub Rule 3 is not going to apply here. Number 2, my lord, your lordship will see Sub Rule 1A. What is the nature of the document which is being considered here? Where defendant bases his defense upon a document or relies upon a document in his possession or power. So this rule 1A.
The document was not even in your possession.
And power. And this document is not being produced now to be received in evidence. This I am saying my learned friend has also accepted this is coming for production. Receiving it in evidence is the next stage. So therefore 1A applicability will not arise at this stage. 13 Rule 1. 13 Rule 1. Original document to be produced at or before the settlement of issues. But this is
Order 13.
Rule 1. This is regarding original documents to be produced at or before the settlement of issues. But this is not, there is no bar upon your lordship to allow. This is not a commercial suit. Then, my lord, my learned friend had also said in his affidavit in opposition that the document is an internal document, part of internal investigation of the ROC. Yes, well, that is why the question of subpoena is arising. So therefore, there is also an admission to this effect that there was some internal investigation. It's not completely manufactured or anything. Investigation has taken place. And if there is no such report, the person will come and say that there is no such report. But the question is, even they say that it is part of an internal investigation.
No, but the thing is this, you did not have a complete
set.
Set.
I'm not supposed to have also. It's an internal document. Therefore, the originator, the source, can be directed by the court to produce that document. There is no bar, and that's the usual rule under the original side rules. One of the principle of issuance of subpoena. That is what I have asked for by way of a prayer. Is it my fault that I am coming to court and asking that please issue a subpoena? Lordship will direct the office of the registrar to issue it.
Now, if you do not produce prior to settlement of issues, you cannot produce it without the leave of the court.
That is why the leave is being sought for.
No, original documents to be produced at or before settlement of issues. That means entire process has to be complete.
Lordship will see, even before settlement of issues, this document was disclosed to them.
Actually, issues are not yet framed. Issues framed.
If the Lordship will see the
No,
order,
that means it is not in compliance with this thing. Order 13, Rule 1. It is not in compliance.
there is no prohibition in law.
So it is directory according to you.
Has to be directly. Otherwise, your Lordship has seen in suits, no documents are produced after issues.
Yes.
They're absolutely inflexible. And not only that, I would
Paragraph 18, page 18.
kindly come to page 18 of the application once. This order, September 8, 2023.
Yes, page.
Kindly take my application.
Yes.
Application page 18.
Yes.
This is the order of September 8, 2023. Kindly see last paragraph at that page. Counsel for the defendants further submit that they have disclosed another additional document and served the copy to the learned counsel for the plaintiff. September 8, my lord. Plaintiff, next page. Plaintiff is at liberty to take inspection of the additional document disclosed by the defendant. Then, my lord, your lordship will see page 20. Issues have been framed on 1st of February. Later.
Yes.
Now, my lord, kindly see.
Well, I think February comes before.
No, sorry, 23. I'm sorry. I thought.
Issues were done.
Sorry.
Oh, this is September 8.
My lord, I am only on the point, my lord, that it is not inflexible. Documents can be disclosed even later. The express prohibition to that effect is only in the category of a commercial suit. In an ordinary suit, that prohibition is not there. Many a times your lordship will find at this stage of evidence the subpoena is issued. Even at the last stage, recalling of the witness takes place, subpoena is issued. Mr. Ghosh has led me in one particular trial, and we have had that, my lord. The attesting witness was recalled. First, my lord, the examination was complete. Thereafter, subpoena was issued. Document produced from the registrar's office. Then, my lord, we recalled the attesting witness. So, my lord, these are positions, my lord, these are procedures which are well accepted by in way of or ordinary suits. Well,
26, page number 26.
26. Now, my lord, kindly see the letter at page 26 by my learned friend's advocate.
Yes, page
If
20.
I may be permitted to say that there was in essence no objection to reliance on this document being produced. Now, kindly see page 26. Under the letter dated 7th September, we have been served with a copy of the inspection report of Deputy Director. We understand, kindly note this, that you will be relying on the said report at the time of hearing of the caption suit. We write to inform you that upon perusal of the report, we find internal page number 11 of the report is not available in the copy. Therefore, we request you to kindly supply us the complete set of report. So, my application is, I will say, in aid of this. It is an accepted position that I will rely upon the report. That is my learned friend's understanding also. So, therefore, I say that let the source produce the original by way of subpoena being issued. My lord, I will just, for my satisfaction, my lord, regarding that moderate rule 1A, one judgment I would cite, my lord, 2020, volume 10 SCC 706. Paragraph 2, your lordship will see. Kindly see fourth line from the top. When the suit was posted for evidence of the defendants. Paragraph 2, your lordship will kindly see. Have your lordship got paragraph 2? When the suit was posted for evidence of the defendants, they filed an application seeking leave to produce certain documents. It was contended that they had recently traced these documents related to the suit property. And that was why they could not produce them along with the written statement. This application was opposed by the plaintiff. Trial court, by its order dated, dismissed the application. High Court confirmed the order. Now, your lordship will kindly come to paragraph 6. Rule 1A has been quoted. Then your lordship will kindly come to paragraph 8, 7 and 8. Subrule 3, as quoted above, provides a second opportunity for a defendant to produce the documents which ought to have been produced in the court along with the written statement with leave of court. Discretion conferred upon the court to grant such leave is to be exercised judiciously while there is no straitjacket formula. This leave can be granted by court on a good cause being shown. It is often said that procedure is handmaid of justice. Procedural technical hurdles shall not be allowed to come in the way of the court doing substantive justice. If the procedural violation does not seriously cause prejudice to the adversary party, courts must lean towards doing substantial justice rather than relying on procedural technical violation. We should not forget the fact litigation is nothing but a journey towards truth, which is the foundation of justice. Court is required to take appropriate steps to thrash out the underlying truth in every dispute. Let the document come. If my learned friend finds that I have telecast, I have said certain things which are not there in the report, it will be better for him. So, my lord, these are my submissions, so that the fact that it has come after the settlement of issues, that should not bar the exercise of discretion by this court, my lord. And lastly, my lord, I will deal with these judgments in the note also, my lord, my learned friend's judgment, and I would like only to make a few comments, my lord, on the next day when your lordship keeps it for filing of the notes. Just 2 minute time I will take, my lord, to deal with this.
No, next day you file your written notes.
And I will deal with these two judgments which my learned friend has cited.
I'll have to
In your written notes of arguments, you want to deal it.
Even orally also.
I have to deal with this. I can deal with it now, or let him finish. Let my learned friend finish, then I'll deal with this.
In your written notes of arguments, you can
I
deal
will
it.
write my written notes.
Written
This note, this judgment that my learned friend is relying on. But
On the next day, both of us can deal with each other's judgment.
the party had applied for leave to rely on a document which they could not trace. They've given the sufficient reasons why they could not produce that document. Here, the lordship will see the press. There's no leave asked for. They just want a direction that these production happen. The leave they wanted to ask for was we were given inspection. Justice Rao's order, your lordship, was shown. They produced an order. They produced a document, Xerox copy. They said take inspection, and that was the leave. Still hasn't been granted. After the issue, 6 months after the issues, or at least 7 months
Thereafter, they
after.
came with the leave after Justice Rao's order.
Justice Rao's order, they came and they said, we want to produce. He said, you give inspection to them. So no leave was granted yet. Now, when I took inspection, it's an incomplete document.
Thereafter, they came with
Then they made an application to produce an original. But they have to first get leave to rely on that document. Or is it they are assuming that leave was not granted? Because they
Implied.
don't come back for the leave. So that document is different. This is the document that was with them. That is one document. That's a photocopy. Now the original is something else. They're asking for production of that. That is to prove that this is a true photocopy that will be required. Not at this stage. They haven't got leave. So this judgment also doesn't apply at all. I will come back.
On the next day, you confine yourself only with regard to the judgments. Rest in the written notes.
Yes. I'll give my note. And my learned friend will also.
Yes. So you submit
Then
your
let us
written.
exchange the
submit
note
your
one day
written.
before.
Yes. Submit your written notes, and on the next day make oral
make our
submission only with regard to the judgment.
Only with regard to the judgment.
Very good.
Yes.
The notes need not be exchanged. Again, it will become like an affidavit.
No, because you have heard both
heard
parties.
Given.
Learned.
He has dealt with my judgments. I have
Mr. Sen, learned advocate for the petitioner defendant, and Mr. Ghosh, senior advocate, learned advocate for the plaintiff opposite parties are present. Our learned advocates, let this matter appear on 20th of June, Friday.
Friday. Next week. Anytime next week.
Only 27th I'm not there. 27th to 1st.
27th, I heard that there may be a holiday on 27th. So when do you want 24th?
Yes, 24th.
Let this matter appear on 24/6/2025 for filing written notes of arguments and yes, filing written notes of arguments. You submit.
Yes.
I'm just
In respect of this GA.
Yes.
yes, in respect of this GA 49 of 2010. Sorry, not 49. GA 2 of 2023. Fixed it in 12:30 যেটা
Matters fixed at 12:30. Item number 7.
But this is
item 3. Item 3.
Item number 3.
Item number 3. I beg your pardon. Item number 3.
My lord takes the fixed matter. Very sorry to interrupt, my lord.
Yes.
So, my lord, item number 19.
এটা হবে না দাদা, এটা হবে না,
Oh, এটা চলবে না? 19 and 20.
No, no, sure.
Okay.
In this matter, there is an application by the defendant for recalling of the decree in the suit. But in that application, affidavits have been exchanged between the parties.
No, not. They have not available. Last of
I am for
in
the
another
plaintiff.
court, they have their original was not tested out.
Yes.
Copy was not served.
Saying
They have
exchange
not-
between the parties.
Not.
I have found that the original was with the office records.
No copy was served, my lord.
What is your GA application? GA?
The erstwhile advocate on record
GS6,
given.
GS6. Old GA malad GA number 1215 of 2016.
So
filed
GA
at the
6 of 2016 needs to be heard out.
Yes, malad. It is assigned before
With
your
the
lordship.
old GA number 1215 of 2016.
My learned friend will supply the copy of the opposition, my lord. I supply, I file a reply, my lord. That leave will be granted, my lord. So, my lord, thereafter your lordship heard of the
You are
application.
representing?
In my application, my lord, I am the defendant, my lord. Dependent one.
No.
It is his application.
My application, my lord.
Okay.
My application.
Defendant's application for recalling of the decree passed in a partition suit.
So that this application is to be disposed
Is to be
of.
disposed of.
Yes.
My lord, may I file the affidavit in opposition, but I find that this was notarized way back in 2016. 2016.
You are for?
But we shall in course of the day serve a copy on my learned.
You are for?
24. They have sold their share of the property.
Anyway, first of all, this application.
has to.
Yes. First
Before
of
a
all,
different bench.
My lord, that bench also desire, my lord, my application will be first heard out, my lord.
only this application is assigned.
Is only this application is assigned.
Yes.
My lord, one more indulgence, my lord. One leave is required, my lord, to file my vocal letter. I am the change brief, my lord.
Okay,
The department
learned-
not accepted, my lord.
No, more probably suit or only application.
No, application is assigned, my lord. Suit, your lordship determination is there, my lord. Suit is your lordship determination.
The application.
Assigned before the other bench, my lord.
Lordship, it would be better if that can be heard before this bench is well together.
Or no, save and
already
accept this
matter
assignment.
cancelled.
This matter I have to hear it.
It is also assigned.
Anyway, because unless that bench releases
Yes,
this,
yes,
that
yes,
matter,
madam,
this
yes,
bench
madam.
cannot hear it.
But I shall in course of the day serve my learned friend a copy of this
Learned
affidavit in opposition.
advocate
If he is
for
saying he has
the
not received it.
petitioner defendant and learned advocate for the plaintiff and learned advocate for the applicant intervener are present. Let affidavit in opposition be filed GA6 of 2016 be kept with the record and copy be served in course of the day. Liberty is granted to learned advocate for the defendant to file the Vokalatnama. Let affidavit in reply be filed by 23.
Well, this is order. Yes, ma'am.
23/6.
23.
Next Monday.
No, my lord. Some, my lord, voluminous, my lord.
Okay,
Opposition is
26th.
26.
26/6.
Yes, ma'am.
2025.
Yes.
And let this matter appear on 30th of June 2025. I have recorded learned advocate for the applicant intervener. Give your names.
Deeply obliged, my lord.
Item number 7.
Really sorry to interrupt, my lord.
Yes.
My lord, item number 19, my lord has two other matters fixed at 12:30 and there are 2 p.m. fixed matters as well as 3 p.m. fixed matters.
Yes.
So my lord, all parties are present. So if item number 19 and 20, my lord, maybe not this week and
19 you are for?
I am
For the plaintiff, he's for the plaintiff.
Okay, you are the joint receiver.
Yes, I'm the advocate commissioner.
And other
Advocate
defendants are also there, my lord.
But 90 I filed an application for addition of partition to.
GA15 is whose application?
GA16 is my application, lordship, taken out by the defendant.
So
number 10.
affidavits in both the applications are complete.
Completed. Affidavits are complete, applications are ready for hearing.
Hearing.
Yes, record and order. Learned advocates.
Defendant number 9 has died, my lord. So that will have substitute.
Who is for the plaintiff?
I am for the.
So have you taken any steps for substitution of
My lord,
defendant number 9?
The heirs are already on record and they have already taken out an application. Application number is not yet given because they are yet to complete the formalities of master summons, etc.
Lordship, the advocate representing defendant numbers 1 to 9 and 12. They have taken out an application for expunging the name of defendant number 9.
So others are on the record. Others are on the record.
All are on
All are on record.
all are on record. So
Anyway, that's a procedural matter that can be done.
only for that procedural latches, it's being dragged out for a considerable period.
Learned
I have no,
advocate
objection,
for the
my lord.
plaintiff and learned advocates for the defendant number
I'm for defendant number 10.
10. Learned advocate for, you are for?
Well, I'm representing the learned advocate commissioner.
Yes, Mr. Ali, you are representing? Yes, you are for the plaintiff.
I am for the plaintiff.
You are
He is
for?
the, I am for the applicants in item number 19.
And learned advocate for the applicant in GA8.
GA 15 and 16.
Okay, GA15 and GA16 of 2024 are present on the prayer of learned advocates. Let this matter
30th of June
appear on
to convenience of my lord, of course.
30/6/2025 at 12:30
My
PM.
lord, I'll be grateful, my lord. Grateful, my lord.
Grateful.
My lord, I'm for the advocate commissioner.
Yes. আচ্ছা ওখানে লিখে দেবেন তো ওই ওদের সাথে as learned advocate representing the advocate commissioner.
Oblige, my lord.
Grateful, my lord. Deeply
Before my
obliged.
lord takes up the fixed matter, my lord.
Yes.
My lord,
My
item
lord,
number 8.
Another thing, he has to, he is under order to provide me inspection. In between, he will provide me inspection.
Anyway, copies have been served. You have filed your affidavits also.
No, there was an order upon him to give me inspection of original.
I have to carry the original. I do not have to.
Okay,
I am carrying the original.
Anyway, let me hear this application there.
Lordship, grateful.
Oblige.
Yes.
My lord, item number 18, my lord.
Number 7.
Yes, 18 what?
My lord, I am being led by Mr. Rajoshi Dotto, my lord. If
Yes,
my lord,
item 17 first. Oh, 17 is the 2 PM. Yes, 18.
yes, my lord, 18, my lord.
Yes, Mr. Dotto is
My lord, he is appearing online, my lord. If
My lord, 18, we would want your lordship to take it up after 2 weeks because, my lord, there can be a possibility of a settlement. That's the, my lord, instruction which I received, my lord.
You are representing whom?
my lord, the plaintiff.
The petitioner, plaintiff petitioner.
My lord, I also have the same instruction. I appear for defendant number 3. I do not have any such instruction for settlement.
Ascertain from your clients.
Keeps it after 2 weeks, my lord, we'll come back, my lord.
কোনটা? এদেরকে এটা ডেটটা একজন করে দিই।
Lordship, I appear for the special officer appointed. There was a direction upon me to undertake some duties, and there was a direction also cast upon the parties, which was.
So did you receive your remuneration? There was a direction to pay some remuneration?
Yes, and then I had to
Conduct
another inspection of the premises. Lord, may I say this, Lord? The parties are submitting that there's a possibility of a settlement.
No, I'm adjourning the matter for settlement. Okay, for further orders. I'm adjourning it for them to take.
Not my discharge, because honestly, I've been appointed a year and a half ago.
No, on the last occasion, probably I remember there was a direction to pay some remuneration.
That has not been complied.
So why it is not complied? There was a direction to pay further remuneration. Yes, Mr. Dotto, why is the further remuneration not paid?
My lord, that has to be done, my lord. My lord, my apologies that the client has not paid, but we will ensure that he is paid, my lord, within the next 2 weeks before we come back to your lordship. I'll ensure that this payment is done.
That it is paid within 2 weeks.
Has to be, my lord. It is the order of the court. We will definitely, my lord, comply.
Not an order. Learned advocate for the plaintiff and learned advocate for the defendant number.
Thank you.
1, learned advocate for defendant number 2, and learned, yes, for you are for 2.
3. For 3. I am for 2, my lord.
Defendant number 1.
My lord, no.
তাহলে 1টা না লিখে করুন learned advocate for the plaintiff, learned advocate for defendant number 2, and learned advocate for the defendant number 3, and learned receiver is present. Stop. On the prayer of the learned advocate, the matter prayer of the learned advocate that settlement proceedings are going on, the matter stands adjourned till July. 23rd of July.
May I just indicate that there is no instruction from my end for any settlement?
No, you take instructions from your client. Okay.
Recorded in that order that the parties, defendant number 3 has no instructions, your lordship. I'll pursue.
Let this matter appear on 23/7/2025. As the receiver is not paid the remuneration in terms of the earlier order, the parties shall ensure that the receiver receives the remuneration as per earlier direction within 2 weeks.
Right.
Learned advocate for the plaintiff and learned advocate for the defendant number 2. 2 submits that the settlement proceedings are going on.
Lordship, may I just indicate one more thing? Lordship, for the remuneration was fixed for inspection of the premises in connection of a disconnection of electricity. That was a matter between the plaintiff and the defendant number 1, your Lordship.
No, the earlier direction is to be shared equally.
Lordship, that was complied with. There was another direction after the report was submitted that was for an electricity
No,
problem.
this court
The
passed an
disconnection of
order. This court passed an order. Let it be shared equally. Thereafter, I shall see.
It was from the joint fund, actually. The order.
Yes, share equally. But it should be done on the next day.
Lordship.
Yes, my lord, grateful.
Defendant number 2 এর ক্ষেত্রে ওই এটা লিখবেন না, শুধু plaintiff and defendant number 1 submits that settlement proceedings are going on. Defendant number 2 টা ওখানে ঢোকাবেন না, কিন্তু presence এ ঢুকিয়ে দেবেন. Yes.
Item number 7 and 8.
My applications, Millard, 2 applications, Millard.
For the plaintiff.
Millard, we are, Millard.
GA 25 and 26.
Yes, Millard. We represent Tata Consumer Products Limited, Millard. This is a checkered history, Millard.
Was the applicant intervener?
No. This is an application, Millard. One application is for dismissal of the suit, Millard, taking off the plaint off the file, Millard. And the other application is, Millard, the orders passed in the suit, Millard. I'm sorry, Millard. I'm led by Mr.
Yes, Mr. Bose may continue.
No, please continue.
No, you are ready. Okay, Mr. Ghoshal, you submit for 2 minutes at least. Thereafter, Mr. Bose will take up.
And the second application, Millard, is for recalling of the orders, Millard. There were series of orders, Millard, passed in the suit, Millard, and Millard, all those orders, Millard, are sought to be recalled in the facts and circumstances of the case, Millard. So this is, Millard, the teeth and substance of these 2 applications, Millard. She will kindly take, Millard.
GA 25 is to be taken up.
Yes, I believe so, Millard. May I? Millard, 2 things, Millard. We had sought for filing certain documents, Millard, that were disclosed in a contempt application which was pending before the division bench, Millard. Those documents, Millard, we sought leave, Millard. Your Lordship was pleased to grant us leave, Millard. We filed 1 supplementary affidavit earlier, Millard, and there were some subsequent, Millard, documents, Millard, which, Millard, we are also, Millard, disclosing today, Millard. Copies have been served, Millard. This is another set of 2 supplementary affidavits, Millard, in GA 25 and GA 26, Millard. May I, with the leave of the court, Millard, fill this, Millard. Copies have already been served, Millard.
So, yes.
Roshni will kindly take, Millard, 25 ones, Millard, GA 25, Millard. This suit is, Millard, in connection with, Millard, certain transfer of shares of Tata Tea, Millard. At that time, it was Tata Tea, Millard. There were, Millard, the plaintiff, Millard, were claiming to hold certain shares of various companies, Millard, and those shares, Millard, were transferred, Millard. In the interregnum period, Millard, a suit was filed and order of status quo was obtained, Millard, way back in 1992, Millard. Then there was an order of the division bench, Millard, directing, Millard, not to part with the shares of the defendant number 6 in the suit, Millard. Millard, in the entire time that had passed, Millard, the suit went for several amendments. If your Lordship take the plaint, Millard, we had annexed the plaint. Lordship will kindly take page 32 of my application, Millard. ওই এন্ডোর্সমেন্ট করা ওইটা দেখো। এটা নয়, যেটা তো প্রচুর এন্ডোর্সমেন্ট তুলেছিল। আমাদের অ্যাফিডেভিট ওটা ডিসপ্লে করা আছে, ফার্স্ট সাপ্লিমেন্টারি অ্যাফিডেভিট। I will take a minute of your lordship, my lord, because there's a lot of documents, my lord, over a period of 30.
Year?
I'm sorry, my lord.
The suit of which year?
1992. Last of such, my lord. But this one document which is not a part of the record, my lord, where, my lord, they did serve, my lord, the amended copy of the plaint along with a writ of summons without the writ of summons, my lord. Lordship will kindly take suit number 611. I do not know if the papers are with the court, my lord. Suit number 611 of 1992. I'm sorry, my lord.
It is not annexed.
It is part of the contempt application, my lord, and as well as the appeal, my lord. But I do not know, my lord, the one the plaint should be with the records, my lord. দেখুন ভাই,
Plainted এটা দেখি। The supplementary affidavit.
Yes, my lord. Yes. Lordship will kindly take, my lord, GA 26 once, my lord. That has been, we have disclosed the original, my lord, plaint, my lord, with the endorsements, my lord. Lordship will kindly take page 38 once, my lord.
Yes.
Lordship will now, my lord, turn to, my lord, page 45 once, my lord. There's the cost title, my lord. And Lordship will see, my lord, there are, my lord, Lordship will first find, my lord, Bhutoria Engineering Works, the second plaintiff. He was, my lord, deleted, my lord, from the array of plaintiffs, my lord, and Lordship will find a series of endorsements, my lord. I will give the dates, my lord. What we can find from the endorsements, my lord, if your lordship kindly goes right at the bottom, my lord, the second last endorsement from the bottom at page 45, amended under order dated 19/4/1996 of the Honorable Justice such and such, my lord, signed copy of the minutes, my lord. That is one endorsement, my lord. Thereafter, lordship will kindly take the next one, my lord, amended under, my lord,
7597.
yes, that is of Justice Sujit Kumar Sen, my lord. Thereafter, my lord, there's another endorsement on the same occasion, my lord, 14/1/1997. Thereafter, there's another amendment, my lord, that was in 16/5/1998, my lord. This was passed by amendment order was passed in by
Division bench.
Division bench, my lord. Thereafter, my lord, there's another amendment, my lord, in 99. My lord, in short, my lord, if I, my lord, summarize before I, my lord, seek leave to ask my learned senior to address your lordship, my lord. All these amendments, my lord, only on the first occasion, my lord, the writ of summons were served upon us, my lord. What we could find from the records, my lord. Thereafter, none of the time, my lord, there was no service of writ of summons, my lord. My understanding is, my lord, every time, my lord,
Orders are annexed, orders of the learned judges.
that, my lord, we have taken inspection, my lord, all these orders are.
Anyway, it is in the record. No, whether
Yes.
you have annexed or not, these copies of these orders.
No, we have not. But all these endorsements are there, my lord. Lordship will kindly take, my lord, at again, Lordship will kindly take page 20, recalling application, my lord. Lordship has to actually simultaneously see both these applications, my lord. At page, my lord, 52, my lord, there's a service report that we have annexed.
Page 52.
In GA25. Now I'm referring to GA25, my lord.
That is page
52, my lord, annexure F.
Yes.
97, nothing else. But we'll kindly see the service report, my lord. The first one, my lord, was served on 7/6/1995. My lord, Lordship will kindly see served upon the receiving assistant for defendant number 3, therein named. We are defendant number 6. Not served on the first occasion, my lord. Lordship will kindly now take the second endorsement, my lord. 2 copies of writ of summons along with the copies of plaint. Lordship will kindly see the date 1/9/1995. Then Lordship will kindly see the 5th column, my lord. Defendant number 1 served. 6/1 was served. Lordship will kindly now take the next column, my lord. There were 2 more services that were, my lord.
Defendant number 4 and 6 served.
But
the last is defendant number 5. Nothing was received for defendant number 3.
Lordship, yes, this is the endorsement I was, my lord. No action was taken, my lord, taken by the plaintiff's advocate for effecting service through the concerned court upon each of the defendant 4, 5, 4 and 6 having its office outside the jurisdiction, my lord. If your lordship now turns the page, my lord, Lordship will kindly take the next endorsement, my lord. In 5/6/1995, my lord, we were for the first time. Last column at 52, my lord.
Yes, 5/6/1995.
Yes.
5 and 15.
I'm sorry.
Oh, regarding you are for?
I'm 6.
6, yes. 5/6/1995.
Yes. Thereafter, my lord, and my lord, Lordship had already, my lord, mentioned earlier, my lord, that if we take this date 5/6/1995, and Lordship again takes, my lord, page 5 of G26, my lord. Lordship will kindly see, my lord, after that particular date, my lord, there has been amendments, my lord.
Yes, after the service of the summons.
Yes,
were amended.
yes, there were amendments. Now, Lordship will kindly come back to page 53 once, my lord.
So when did you enter appearance in the suit?
Summons were never served.
No, 1995. 95, 95.
Mr. Bruce, my lord.
Yes.
Now, my lord, I'll be very what these applications are about. You see from the cause title, this is a suit of 1992. Right. I'm defendant number 6. I'm implemented as Tata. My lord, this is the new name. I am implemented as Tata. My lord, initially, if you see the plane, Tata T. Now, my lord.
Tata Consumer Products Limited.
No. You are seeing the amended.
Amended, you are Tata T.
Tata T. Unamended is Tata T. Now, my lord, when the suit was filed in 1992, I was Tata T. Now, my lord, I became Consumer Products much later. My lord, probably in 2009 or side, that's a different issue. Now, my lord, this change of name to Consumer Products happened, my lord, in 2023 by way of an amendment. And my lord,
you are representing the new company.
I have to, because my lord, it's a change of name.
Earlier.
Earlier it is Tata T.
Now
it is Tata Consumer. So matter appeared for an amendment application in 23 without directions for affidavit. My lord, the amendment has been allowed and name of Tata Consumer has been added. Now, one of the odd things which I am recalling, if you see GA 25, is that order by which this has been added. The reason why I am saying this is, my lord, the suit was a dead suit because, my lord, writ of summons was not served for all these years of 25 years. So before you could grant an amendment, my lord, it was imperative at least to see whether the suit is alive as against me or not. That is the reason I am asking for recalling of several orders which were passed, my lord, just, my lord, by oral mentioning or by some of the orders by oral mentioning in a pending and in a GA 23 of 2023 where no directions were given for affidavit. My lord, I appeared. It's not a fact I did not appear, but subsequently it is, my lord, what happens? You can file amendment at any stage of a suit, right? Provided, my lord, there is your initial, my lord, firstly, the suit must be an alive suit. By virtue of the fact, my lord, there is a time limit when summons are to be served. If you do not, my lord, serve summons, and appears there are about 15 amendments carried on from 1995.
Amendments with regard to only cause title or from the pleadings?
Pleadings also.
Pleadings.
That is what I am saying, my lord. On pleadings also, including death of a person pursuant to will. Someone else, a gentleman called Manmal Bhutoria, was initial defendant, died in 1998. Died in probably 98 or whatever, leaving behind a will. Will probated in favor of wife. An amendment carried out in 98. No summons served. Why I am saying this? Because one of the principal reliefs is, so far as Manmal Bhutoria is concerned, the dead person. So, my lord, when a person is implemented in person state and said that instead of Manmal Bhutoria, his wife is now the holder of the shares of Tata T or Tata Consumer.
That is defendant number?
6.
6.
My lord, Manmal Bhutoria is plaintiff. My lord, probably substituted plaintiff number 2.
Plaintiff number 2.
2, you
is
will.
Manju Devi Bhutoria.
That is the substituted. Substitution done in 98. That I will show you. Now, my lord, because husband was the owner of shares in Tata Tea. Right, my lord? At the time, my lord, when substitution was made, these shares, which were held by Manmal Bhutoria, had been sold to another party way back in 2006. Now, my lord, it was imperative, I humbly submit, that, my lord, when a substitution is being done in the year, my lord, 1998 or whatever,
96, 97, 98.
whatever it is, my lord, a new person becomes the owner of the shares. The company, a company as big as Tata, must be told as to who the owner of the shares has now, by virtue of amendment. They carried out the amendment, but did not. No summons, or everything was served. Now, my lord, as far as the law I know, every time you carry out an amendment, a summons has to be served. A fresh.
How many times did they fail to do these things?
About 15 times.
15.
Probably, maybe 12. I will go on counting, because all I have is that plaint which was being shown in GA 26. Just look at flip the pages.
Yes.
And it is what you call in Bengali chochori. It has become like this. Now, my lord.
That is the consequence.
Now, you, what to do? So someone, my lord, a company, the real cause of action, I will tell you what the cause of action is. Big companies are involved. Tata, Grasim, Unit Trust, this Monmol or Bhutoria are the owners of various shares, were the holders of various shares. That is the cause of action in 1992. They say, my lord, in those times, the demat and all these things had not happened. Now you cannot sell shares unless it is demat. Why, my lord? Security. That, my lord, previously, if your lordship had
You have to cross these tests.
Yes. Now, my lord, there is nothing called anything called fraud were happening, because it's all dematerialized. Now, previously, my lord, in 1992, there was a series of litigations, and this is a product of one of the litigations. What happens? There was there were share brokers in the market. Now it is directly monitored by the stock exchange. My lord, this broker, Bajrang Mahabir Prasad firm, was a broker. What people used to do, my lord, suppose you were the owner of various shares and you wanted to trade in the market, various shares. You would park all your shares, my lord, in this broker. And most of these brokers were corrupt people. So, my lord, valuable shares parked in favor of this, say, Bajrang Mahabir Prasad, who is now absconding, never to be traced. These shares were lying with him. And, my lord, by oral instruction, these people used to give side, you sell so many shares and adjust it against my account. They used to maintain a running account. Now, my lord, it is a fact that there was at that time a lot of litigations happened, my lord, in 1991, 92. They were the side, and that is one of the reasons why SEBI came in 1992, and all these things about dematerialization, and also SEBI was enacted in 1992 as a market regulator. Now, my lord, I'm just giving you a history so that you understand what the plaint is. Now, my lord, what happened? So these people, there was on the basis of share transfer deed. So you blank share transfer deed were lying with these people, my lord, with these share brokers, and over the phone they used to say, this share has gone up, shall I sell? Nothing written. So much is outstanding. I will adjust against this. And similarly, who is the buyer? He was also registered. The brokers were there. No longer it is there. So what happened?
Moral instruction.
Where it says, when the dispute happened with this broker, invariably, if it was a broker, a corrupt broker, a person, a genuine person, provided he was genuine, a seller, they are all traders in the market. It said, I did not sign, that is not my signature in the blank share transfer deed. And the dispute would start that I did not sell. This is an example of one such dispute. By this, the companies, the big companies, were tagged in. Therefore, you will find who are the parties? Grasim, now Hindalco, all big companies. This is exactly what has happened. Now, he had a dispute. This gentleman, plaintiffs have had dispute in respect of their shares, which were the original. In those days, it was original share scripts. Remember, original share scripts. Yes. Now it's not possible. Now you have to, if you want to share, if your lordship is owning, I don't own much. Most of them have to be, you can't sell unless it's dematerialized. This has been done to protect this type of fraud. Now, what has happened, in this matter, in 1992, these persons, the plaintiffs had dispute with this Bajrang.
The defendants.
With the Bajrang and all, who are now absconding. And so I did not sell these shares. And the big companies were getting entangled. So restraint orders used to pass, injunct the companies, random aside. Big companies were suddenly drawn. Now, in this case, what has happened, in open market in 2006, a person who purchased the shares from Manmal Bhutoria, 1,000 shares, apparently filed a suit in the city civil court and got a decree
against the
saying, yes, saying decree against, and the purchaser said that I am not registering the new name. The purchaser, who had actually, through probably the broker, I do not know how he managed to get hold of a site, said I am the owner, and he got a decree for declaration from the city civil court in 2006. And then send these transfers to me for transfer, which I did. That was in 2006. Now, nothing remains of me. That person has not been made a party. So instead of that, they go on flogging a dead horse, flogging the company.
This is the background of the
This
case.
is the background of the case, and I
with
will
these
show,
applications you
and I will show, from the side why I am aggrieved is when the holder of the shares. Am I crossing the line? Sorry.
No, these applications is
So I say when
non-compliance of the rules.
No,
This application is
Yes. It's not non-compliance of the
background is not important because you see merits cannot be gone in your
Certainly, it cannot be done. But, I need to know that the plaintiff who has died, who is the owner of the shares, opportunity must be given, to serve summons so that I can file a written statement.
Yes.
You cannot do it. You cannot do it, revive a dead suit after so many years in 23 by saying your name has changed. And then a starting point of limitation again begins.
Anyway, admittedly, there is a non-compliance.
Non-compliance, my lord.
So plaintiff, original plaintiff, substitute, whatever.
Yes, I needed.
So whether if your application succeeds, and the suit will go.
Right.
If you can justify.
Correct, my lord. Therefore, for that I must do two things. I must first file an application for recalling of the orders in 23, where by reason of change of name of company, this amendment has been allowed. My lord, because when you allowed that amendment, the suit was dead already. Therefore, you will find this is GA 25.
No, if a suit is dead.
Yes.
Under the law, whatever it is.
Yes.
Any order passed, that's a nullity.
Nullity. That is why I have asked for recalling. And in any event, I should have given and been an opportunity to file an opposition at least to explain these things.
It was done in their presence.
Both are your application.
Did you not ask
25
for
and
any
26.
My lord.
25 and 26 are your application.
And 26 is more fundamental. Fundamental in the sense, if a person, this Manmal, whose name was not changed to Monju, he has already transferred the shares to another, and not receiving dividend in the records of the company, someone else, and you don't bring that person on record for all these years, the suit is dead.
Did you file any application for condonation of delay and extension of time to serve the summons subsequent?
But subsequently, Lordship, they have received the summons.
No. Question is, you see.
Lordship, we have, Lordship, in our opposition.
After the amendment was carried out.
Lordship.
And the opportunity was granted to you to serve the summons, and there is some default on your part. Did you take out any application?
Lordship, I have, this is an old suit, my lord. I have got letters. I have annexed those in my opposition, by which I have served the amended plaint to my learned friend's advocate on
anyway, in accordance with law.
Lordship.
The formal
and Lordship, in our original side, Lordship, this is very common. Writ of summons is waived.
I have waived it.
That is a different
That is
issue.
now that they are saying they have got waived.
Question is, because you see, normally the procedure is you file an application for condonation.
Because opportunity to file written statement, amendment arises thereafter.
Condonation happens only, Lordship, but right now, after Lordship, we stepped in. They have received the amended state. They have received writ of summons has been lodged.
Your application is dated when 2024.
Mine is 24. I am asking for recalling of. He says after this happened in 23. I am also saying in 23, and I am asking for recalling.
Your client was earlier you appeared from the former company.
Former company always. Millard, there.
The new company
applications,
yes,
everything.
Millard, now well, company is one. It's a change of name.
This application, Mr. Barshu's client, this is the new client. The present client was.
It's the same client. It's a change of name, right?
It is
So
under
the Order 22, Rule 10A.
Rule 10.
Order 22, Rule. Yes. My lord, whatever it is, my humble submission is every time a person, if a plaint gets amended, a fresh writ of summons has to be issued, unless, of course, I waive it.
That is why I'm asking him whether he took out any.
No, that's what I'm showing. He showed you the report, the default.
What's on record is that the letters.
It is sought dismissal. The other side, they filed an application for condonation. So whether Mr. Ali's client has taken this up. Anyway, you justify your case.
Lordship.
No, when is your lordship fixing?
So I'm fixing it on the next day instead of arguing both written notes and argument. Argue from your written notes. It would be better. Instead of hearing
may I argue and then give the written note? Just
whatever is convenient.
And if you, I'll make. I certainly. I mean, before he starts.
Otherwise, again,
before he starts, certainly. But I will. My lord, when is your lordship first keeping it?
I'm taking it. If I have to fix it, then I have to see some date.
Yes.
If it appears in the usual course, then it's a different issue.
My lord, it's up to your lordship and whatever you want.
This is a 1990 suit. Only one thing is that I cannot proceed with my suit because of these applications.
শুনুন এটা এই হ্যাঁ তো দেখে নিন 24-25 তারিখে বা 19 তারিখে দেখুন
তো 19 তারিখ যেটা মানে instead of 19th, 20th or 20, not whenever that is possible.
24-25 অনেক ম্যাটার ফিক্স আছে 23 তারিখে নেই 23 তারিখে কি করে দুটোর সময় একটা 3টের সময় দুটোর সময় একটা ম্যাটার ফিক্স আছে ও আচ্ছা তারিখের আগে হচ্ছে না Yes, 19th you have some difficulty.
Yes. And when the rest is, he'll be arguing mostly. I will just,
I'm just
he
considering.
was, so
কবে আছে
please,
30 তারিখে
please come.
হ্যাঁ এটা তো 10:30টার সময়
করো
শুক্রবারে তো টাইমটা লিমিটেড না
19 তারপরে জাতি আছে তো নোটস রেডি করতে হবে না
আপাতত কিছু নেই Yes, 26th at 2 p.m. Any?
No, I don't have any.
I shall be present. 26th. Yes, record and order.
Lordship is fixing at 2 p.m.
Yes. Learned advocate, Mr. Basu, learned advocate for the petitioner defendant number 6, and Mr. Ali, learned advocate for the plaintiff, are present. Mr. Basu commences his submission, but could not conclude the same. Let this matter appear on 26/6/2025 at 2 p.m.
I'm great.
Yes, item
26, your lordship.
26, it is fixed.
No, it is not fixed, your lordship. It's an old suit, your lordship. Special referee was appointed and he has filed a report. The extent of
So come at 2 p.m.
Thursday, your lordship.
You are praying for not today.
I'm praying for keeping the matter on Thursday, your lordship. I will am filing an application for taking the report of the special referee.
Other side is here.
I will inform the other side. Mr. Uttam Mondo is there. I have already.
You are for?
I am for the plaintiff, your lordship.
Acha, record করে নিন তো item 26 on the prayer of learned advocate for the plaintiff, the matter stands adjourned till 23/6/2025. I'm keeping it on next Monday.
Same as 34 and 35, my lord.
Your
I
lordship,
have to leave for more medical ground at 2 p.m., my lord.
Yes,
34 and 35.
34 and 35 is fixed.
not fixed, your lordship. I appear for the plaintiff in item number 34 and for the defendant number 2 in item 35, your lordship.
Yes, what is the difficulty?
Actually, when 2 p.m. at 6, my lord, when I have to leave for my.
I'm making it not today then.
Your lordship will adjourn it for 2 weeks. The parties are considering
Acha,
settling
ছেড়ে
the
দেন,
matter,
এটা
your lordship.
34 and 35.
Yes, your lordship.
Acha, on the prayer of learned advocates for the parties, the matter stands adjourned till 2/7/2025.
Grateful. 2 p.m. matter, Your Lordship, may I be permitted to mention one matter? Your Lordship, item 33 of today's list, Your Lordship.
Yes.
On the last occasion, Your Lordship had directed the department to file a report as indicating as which defendants have filed the written statement and which defendants have entered appearance in the suit, Your Lordship.
Yes.
So, Your Lordship, I was praying that a copy of the report may be handed over to us, Your Lordship.
Let it be called on.
Your Lordship,
Let it be called on, I
we
should
have a
see.
matter fixed at 3, Your Lordship. If I'm not there at 3, Your Lordship will adjourn the matter then.
Okay.
Matters
Yes.
fixed at 2 p.m. Item number 17.
Pass over.
হয়ে গেছে এটা?
Adjourn হয়ে গেছে নাকি? 17? আচ্ছা 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 ঠিক আছে
ঠিক আছে। Estimating matters, item number 21.
This is my application. Item number 21 and 22 pertain to a similar matter out of PLA 134. But item number 2 is GA2. This is my application. This is an intervening application in GA1. But I am led by Mr. Aniruddha Mitro.
So I'm passing it over.
Yes, my lord, kindly pass it over.
Item number 22.
Yes, yes, both pass over.
Item number 23.
Lordship, the advocates on record is admitted to the hospital.
Yes.
The advocates on record is admitted to the hospital. So
Not this
kindly
week?
give us 2 weeks time.
Okay, on the ground of illness of learned advocate for the petitioner, the matter stands adjourned till 25/6/2025.
নামটা দিয়েছেন?
You prayed for 2 weeks time?
Yes, sir.
আচ্ছা তাহলে ওটাকে 25-এর জায়গায় 30 করে দিন।
Item number 24.
Yes, pass over.
Item number 25.
Yes, pass over.
All source, item number 27.
Yes, pass over.
Item number 28.
Yes, pass over.
Item number 29.
Pass over.
Item number 30.
Yes, pass over.
Item number 31.
Yes, pass over.
Item number 32.
32, yes, pass over.
Item number 33.
Yes, 33 you are appearing for?
I appear for the plaintiff in this suit, Your Lordship, on the last
Okay, let me
occasion.
see the previous day's order.
Yes, Your Lordship. The order dated 7th of May 2025.
The matter was that due to appear on 11th June. Yes.
Yes, Your Lordship, it did not appear on the 11th of June.
Okay, report has come. Record an order. No report is submitted. এটা কবে 7th May এর পরে কি? না না এটা আরো আগে। No report is submitted by the department in terms of earlier order dated 7th May 2025. Let the report be submitted on or before 23/6/2025.
Grateful, Your Lordship.
Item number 36.
Yes, pass over.
Item number 37.
Yes, pass over.
Item number 38.
Your Lordship, I have applied before the department to obtain the information whether the defendants have entered appearance or not, and when the mode of the service has been completed. The record is not with me right now. I'll obtain and I'll come back, Your Lordship, if it adjourns it for a week.
Meeting in not this week?
Yes, Your Lordship.
Acha, item number 38, not this week. Not this week.
Item number 39.
Yes, pass over.
Item 37, my lord. Item 37, my lord.
Just wait.
Just,
Item 39, pass over. Yes, item 37.
my lord, I was just praying for adjournment because we have to take further instructions, my lord.
You are appearing for?
Plaintiff, my lord.
Yes,
More,
item
more,
37. On the prayer of learned advocate for the plaintiff. 37.
Yes, my lord.
Prayer of learned advocate for the plaintiff. The matter stands adjourned till 24/6.
My lord.
24/6/2025. Yes, second call.
Second call, testamentary matters. Item number 21.
But there are two general applications in the list. One is GA1 and the other one is GA2. So for GA2 is concerned, I am the petitioner. GA1 is okay, Rohit Banerjee. Mr. Rohit Banerjee is the petitioner in GA1. Now, so for GA2 is concerned, it came out in the year 1996, a probate was granted by this honorable court. After all these years, in the year 2025, the GA1 was filed for revocation of the grant, which was allowed in 1996. That is the GA1. GA1, that is the prayer, GA1. Yeah. GA1, that is the prayer because we have not been served.
No,
now,
GA1 application for revocation of the grant of probate.
Yes, the grant is.
And GA2
is my intervention application.
Let me see GA2.
I basically oppose GA1. I say that it can't be.
You are not a party in GA1.
I am not a party in GA1.
What capacity you want to intervene?
Yes, what capacity I want to leave to intervene, my lord. Lordship, I have said in paragraph 2 of my application that the intervener is a son of Rai Bahadur Motilal Chamaria. Now, if Lordship see, I'll tell you the genealogical table. That will be easier because it's a bit of complicated family tree. Page 35 is the genealogical table. The probate proceeding is of Gomti Shethani Chamaria. If page 35 is the genealogical table, the family tree that.
Yes.
So the probate proceeding is of Gomti Shethani Chamaria. He is the first wife of Rai Bahadur Motilal Chamaria. The second wife was Sheila Devi Chamaria. I am the son of Sheila. Now what happened? On the death of Gomti, application for grant of probate was filed by Bijoy. Bijoy being the son. And the probate was granted. Now, there are several properties, litigations, 5 or 6 in Calcutta High Court with regard to the estate of Chamariyas, the Rai Bahadur Chamaria.
No,
Even this
who left a will,
Gomti.
Gomti.
Gomti left behind a will. Gomti left behind a will. Gomti's son Bijoy applied for the probate and probate was granted.
Yes.
Now today, the GA1, who is the petition in GA1? And now,
it
Lord,
was
you will see-
granted this will of
Yes.
Gomti Devi
probate was granted in 1996.
1996.
1996. The probate was granted.
Which paragraph you have stated?
Mila. Paragraph 13, my lord.
Paragraph 13.
Paragraph 13, that I have said after 28 years.
So you are a beneficiary of the earlier will.
I'm not a beneficiary of the earlier will. The difficulty is, should we kindly come to the family tree once again?
Yes.
Now what's happening is the facts are very complicated that I'll just try to erase out as possible. Now, Bijoy Chamaria, the son of Gomti, applied for the probate.
Yes.
Probate was granted in favor of Bijoy.
Yes.
Now, today, in the passage of time, Bijoy died.
Yes.
The property has come down to Anirudh, son of Bijoy. It has come down to Anirudh. Now, so the estate of Gomti through Bijoy has come down to Anirudh. Now, today Anirudh has also died.
Yes.
Around a year back. So there is another.
Without leaving any will.
Without leaving any will, he died as a bachelor. Anirudh died as a bachelor. Her mother died earlier than Anirudh. So Anirudh died as a bachelor. Without leaving behind a will. Now, then what transpiring today is there are 2 wills coming up. I say of no living intestate. Now today the 2 wills are surfacing. In this honorable court, there is already a probate proceeding filed in the goods of Anirudh Chamaria. Now what's happening? The moment I contest that Anirudh has died without leaving behind a will, I being the stepmother's stepson, I come in as a legal heir.
No, Anirudh Chamaria died as a bachelor.
Anirudh, I say, as a bachelor. But I say without leaving behind a will. Today, this application, which is GA1 is taken out by Amit Dhandania.
Revoke the grant of probate of the will left by probate of granted with regard to the will of Gomti Chamaria.
Gomti Chamaria. After 28 years. So I say that what's becoming, why they do this, I have a caveatable interest in the estate of Anirudh. This court has accepted the caveatable interest and my caveat is already on record in the estate of Anirudh.
With regard to?
Anirudh.
No. In which case you have a caveatable interest?
In the property left by Anirudh Chamaria.
That is in PLA. No.
This is PLA 95.
This is PLA 95.
Lord, she will come to genealogical table.
So your caveatable interest was accepted by the court when?
Last year in the estate of Anirudh Chamaria.
Yes.
I'm for the applicant.
Yes,
I would have
GA1.
thought for
No, GA2. Mr. Mitra is moving
I would have
GA2.
thought for 1 week's time.
No,
File
GA2,
opposite.
GA2.
And he wants to file up. I know I cannot press for
week's time.
because he was not here, so I was explaining to the court what is the
I'm sorry, but I
background.
was stuck in courtroom.
Now, any event I cannot press for identity murder as on date because there is no scope for identity murder.
Yes.
I have prayed for a liberty to intervene. So if I get the first prayer, then only the other prayers will follow, which Mr. Banerjee will always oppose.
Yes, record and order.
Yes,
Mr.
I'm sorry,
Mitra,
Lord, I'm sorry.
for the applicant in GA2 of 2025 and Mr. Banerjee, opposite party in GA2 of 2025 are present. GA2 of 2025 is taken up for consideration. As this matter is to be decided on affidavit, let affidavit in opposition which be filed by 23-6,
Yes, my lord.
23-6, 2025. Reply, if any, by 26. 26.
No. My client is in Bangalore based. That is the difficulty. You will come and sign.
Okay, 1-7.
1-7. Yes.
1-7, 2025.
Yes, 100%.
Let this matter appear on 2-7, 2025.
2-7.
My lord, may a time be fixed, my lord, if it is possible, and my lord,
So this is GA2.
GA2.
Yes.
Very short argument on my point I have seen.
No, you have to file your affidavit.
Yes, but if your lordship is pleased to, my lord, fix it any time, my lord, half an hour would suffice. Subject to what Mr. Mitru, learned senior advocate, says and comments to your lordship's list, my lord.
Whatever. I am not standing in the.
If it is only comments to your lordship.
Anyway, if this court does not reach, if the matter is not reached, I shall fix it.
It generally reaches.
One just small request. On the last occasion also I had appeared.
In this matter?
Intervened in this matter. I am appearing for one Mr. Neeraj Khanna, who is the beneficiary of a will executed by Mr. Anirudh Chamriya. Anirudh Chamriya's father had obtained the probate of this will, of which revocation is now sought by Mr. Banerjee's client.
You file a separate application.
Your Lordship had indicated that I should file a separate application. My application is ready. The only difficulty is I do not have the cost title, which is why I'm unable to file it before the
Anyway,
department.
file it with a short cost title.
Then maybe why not I might require your Lordship's
You get it ready and then obtain a leave.
Well,
Let
I
it
will
come.
do that.
শোনো ভাই আমার কাছেও ছিল না এখানে এসে দেখে চোখে দেখে
This application
I
has
mean,
to
I
be hard
didn't
out
have the
first.
cost title. I have filed it. I didn't have the cost title also.
GA2 has to be hard out first.
Yes. Deeply obliged.
Second of July.
কৌশল আমার কাছেও ছিল না
Yes, it will appear on it will appear on 2-7.
2-7. We'll argue that man on 2-7. Deeply obliged.
Item number 24.
Yes, not today.
Item number 25.
Not today.
Item number 27.
Not today.
Item number 28.
Same, not today.
Item number 29.
Not today.
Item number 30.
Not today.
Item number 31.
Your Lordship, in item number 31, I appear on behalf of the respondent, the defendant, Your Lordship.
You are for the defendant.
Yes, Your Lordship. Your Lordship, on the last occasion, you had called for the report.
So you have served
Now,
the learned advocate.
we
for
had
the
served, which has been kept in the record, and administrative notice had to be required to be served upon the plaintiff,
Let me see the record order. Last
and
date.
a report to be submitted. Lordship.
Administrative notice sent up হয়েছে administrative notice দেখুন তো রেকর্ডটা ইপিএম এ হবে ঠিক আছে হ্যাঁ বুক পার্টি যদি সিপিএম এ থাকে করে দেওয়া হবে আচ্ছা আর 41টা আচ্ছা আচ্ছা ঠিক আছে এইটা দেখুন এটা ইয়েস কিনা অ্যাডমিনিস্ট্রেটিভ নোটিস কিন্তু নোটিশটা সার্ভ হয়েছে কিনা সেটাও কিছু বোঝা যাচ্ছে না। নোটিশ সার্ভ হয়নি, অ্যাডমিনিস্ট্রেটিভ নোটিশ। রেকর্ড অ্যান্ড অর্ডার। Learned advocate for the defendant is present. It appears that in terms of order dated May 6, 2025, administrative notice is not served upon the plaintiff and his learned advocate. Let administrative notice be served upon the plaintiff and his learned advocate. Let a report be submitted on or before 16/7/2025. Let this matter appear on 17/7/2025 for report. Report.
Item number 32.
Yes, not today.
Item number 36.
Not today.
Item number 39.
Not today.
Witness action. Item number.
Item 41.
41.
Lord, pursuant to your lordship's last order, my lord, we have served the defendants once again about the matter today. Lord, only one thing, my lord, I would be seeking for a 2 weeks accommodation because the instructing advocate in this matter is suffering from COVID, my lord.
41 is due to appear for examination of witness.
Yes.
You are representing?
The plaintiff. Lord, we have served pursuant to your lordship's last order, my lord, kindly cease. On 13th May, your lordship directed us to intimate the defendant about the next date. We have served, my lord. Every bit of service.
Defendant's advocate.
Defendants, the defendant directly over the defendant.
As well as you serve the advocate also.
My lord, prior to that, we have served the advocate.
Okay, record and order. Learned advocate for the plaintiff is present. None appears for the defendant.
Lord, only thing, my lord, the service is, affidavit of service is not ready, my lord.
Okay,
I'll
learned
just hand
advocate
it
for
over.
the plaintiff press for time to take necessary steps and file affidavit of service. Let this matter stand adjourned till 1/7/2025
For
at,
witness.
at 3 for witness action at 3 p.m.
3 p.m. Grateful. একসাথে for এটা আমার পিছনে।
Item 42.
42, yes, ma'am.
42 parties are present.
No, madam, my witness is present.
It is fixed at 3 p.m.
Yes, it is not coming with the endorsement at 3 p.m. It has not in the list. It is not
No,
coming.
but it was also mentioned for taking it up at 3 p.m.
Yes.
Probably.
তুমি mention করেছিলে?
No, it was not mentioned.
No, at 2 p.m. এটা দেড়টার সময় মেনশন করেছিল কি? ওটা
না। একটু লিখেটা দাও না বাবা।
কিন্তু ওই আদার সাইড তো নেই।
অর্ডারটা তলায় লিখে দিও 3 p.m. না? Must have missed.
No, actually it is not written. Probably in the order it was mentioned 3 p.m.
No,
Yes, my lord, order is there.
Yes, order it is mentioned 3 p.m.
Action at
So
3
other side advocate may come at 3 p.m.
Then
So anyway, I'll take it up at 3 p.m.
Lordship will have to rise then.
No, I'll rise and sit at 3 p.m.
খবর দাও না চেনো সুকল্যাণকে তো চেনো সুকল্যাণ আইপিআর করছে না দেখেন
Yeah, if possible, intimate the other side advocate.
I'll just try to contact the defendant advocate because my witness is present here.
Hey, take it. Huh? ঠিক আছে।
কোথায় গেল?
Witness action, item number 42 fixed at 3 p.m.
There was a judgment upon admission fixed at 3 p.m. Yes.
So far witness action is concerned, I contacted the defendant, they said they are coming. So if the other matter, I can't hold up the court, my lord.
Is appearing leading me this matter, my lord. He's on leaks, my lord. And praying for short possible.
Yes, which item?
No, that is a witness action.
Witness
The
action.
witness action, if the Lordship is having another witness 3 p.m. matter, item 16 I find.
41 is done.
Item 16.
16 is a 3 p.m. matter. That if
My
that
matter.
can be, if that can
Madam,
be heard,
Mr.
so because Mr. Ghosh, it's
Item 16, your application is fixed for witness action or GA?
GA, my lord. Well, that was judgment upon admission. If you recall, Mr. Thakkar had completed his argument. Mr. Bar at law was supposed to complete his argument, which he had been delaying after delaying again. As your lordship knows, they don't have any difference.
Question is, Mr. Thakkar is to give the reply after Mr.
No,
Bag completes.
No, Mr. Thakkar has completed.
No.
Prior to vacation, it was Mr. Bag who is supposed to.
So you have
complete
to
his
submit
argument.
now.
I have to submit.
Thereafter, Mr. Thakkar will reply.
My lord. They were supposed to come with the law notes.
I don't know once we complete our submission.
Anyway. Yes, I'm taking this matter thereafter.
Item number 16.
At 3:30, I shall take it up. You have filed your opposition.
We have, my lord. Pleadings are complete, my lord. Petition. May it please your lordship. My lord, kindly take up broad pointers, my lord, before I start my submissions. At this stage, I have to only indicate that this is a matter which is to be relegated to trial. They are seeking a judgment upon admission. Order 12, Rule 6 is a petition before your lordship. But my only endeavor will be to indicate why this matter needs to proceed to trial. What are the issues involved? First thing which I am sure Mr. Thakkar was not instructed is that this point was taken before and it was not considered by the court. I'll come to that. So this point that this petition is barred by res judicata and constructive res judicata will be something that I'll be arguing. Because they have filed the petition under Order 12, Rule 6, where they have made the following prayers. Will kindly take up page 25.
Yes.
Judgment on admission and decree for eviction against defendants 5A, B, C from the open area marked in pink, hatch on map being annexure B. Injunction restraining these defendants from parting with possession ad interim costs such further orders. That's the premise of the Order 12, Rule 6. What is the premise? I asked myself this question, my lord, of the plaint. What is What is the premise of the plaint? Why has the plaint been filed? Kindly take up the injunction first. I'll indicate from because it's the same pleadings. Your Lordship will kindly take up page 57. From their petition, I'll show.
Yes.
You have the plaint, right? Separately. May I pause here for a moment, but may I first indicate from the plaint, because what is the premise of the plaint I have to indicate, and how they are saying it's Order 12, Rule 6. Kindly see the plaint once. It's a separate.
No, it was a suit to evict a trespasser.
My lord. Under what provision of law? Because my lord, today, if they
It
want
was a suit to evict a trespasser, thereafter, subsequent cause of action.
now they say, my lord, that without a notice under the Premises Tenancy Act, they say by the dint of operation of law, I can have you evicted.
Yes.
Because of an admission in law that you don't have the, my lord, the benefit that the tenant has under the Premises Tenancy Act. The operation of law, the 5 years operation of law and the legal heirs. That is their main contention for the Order 12, Rule 6. But what is the premise in which they have filed the petition and the plaint? Kindly take up the plaint, my lord, once. Very quickly, in 5 minutes, I'll indicate. I'm coming to that. Wait.
Yes.
Plaintiff 3 files this, my lord. The plaint says plaintiff 2 has been. This is paragraph 3, my lord.
That is page 57.
My lord, no. I'm indicating from the plaint. Independently from the plaint, I'll come to page 57, my lord.
Yes.
Paragraph 3. The plaintiff 2 has been and still continues to be the tenant of the demised premises. Plaintiff's occupation. This is not since 1978. Plaintiff's occupation and possession of the demised area is borne out from inter alia the following: A and B, report of the special officer, rent receipts. At all material times, the access to the demised area has been from Armenian Street in the north and common coverage area south. I'm not troubling a lot with that. Can you see paragraph 5? In 2000 August, lawfully sublet the demised area to plaintiff number 1. Plaintiff 1 has been regularly paying rent by account pay checks of the demised premises. Over the page, my lord, the rear open area, paragraph 6,
yes,
forming the part of plaintiff 1's tenancy, has been wrongfully used as dumping ground for garbage by those in occupation of the first and the second floor. Since 1993, defendant 5 has been obstructing the user, the enjoyment of the demised area. Subtenancy was created by plaintiff 2 in favor of plaintiff 1 on the specific understanding that garbage from the open area would be removed. Plaintiff 1, after taking subtenancy in respect of the demised premises, started taking immediate steps for removal of garbage from the open area so as to make the shop room or godown forming a part of the demised area accessible from the northern side without any obstruction.
From the southern side.
I'm sorry, from the southern side without any obstruction. Plaintiff 1 through so-and-so, director of plaintiff 3, started taking steps. This is on the merits. Over the page, kindly see. They claim unauthorized structures, paragraph 11. Certain unauthorized structures have been erected at the first floor level on top of the garbage. These structures are unauthorized and illegal and have been erected by the defendant numbers. This, if allowed to remain, these structures poses threat to the safety. Paragraph 12, duty and obligation of defendants 6, 7, 8 and other defendants to remove the unauthorized structures. Paragraph 13, defendant 1, 2, 3 and 4 in collusion and conspiracy with other defendants, wrongful intention, unlawfully fixed a shutter on the southern side entrance of the plaintiff's portion sometime in 2006. Previously, there was no shutter or gate, demised portion. By affixing the shutter, defendant 1, 2, 3 and 4, so this is the allegation. In conspiracy, they are obstructing free ingress and egress. So far as the northern side approach is concerned, defendant 5, that's not us, is obstructing free ingress and egress of the Armenian Street entrance, the northern side. Paragraph 15, defendant 5. We are for defendant 5 ABC, my lord. So this is for us, my lord. Our predecessor in interest. Defendant number 5.
Against whom is this judgment on admission sought?
Against us, 5 ABC.
5 ABC.
5 ABC.
Against the substituted heirs.
Against you.
Against us.
Okay.
Against
Against us.
substituted heirs, they are
So far,
sponsored by operation of.
so far the others are concerned, no such prayer is
They
made.
have given up all their rights.
Now
And
they have
there is a
given up.
order
So
by
this is
Justice
the way
Indra
we
Banerjee.
want. Now
Anyway,
no-
no
no
relief
right.
can be granted if they have not prayed for.
they've not prayed. Now I'll indicate why this is not maintainable. I'll come to that. I've indicated that once. I'll come to that in details. You kindly see paragraph 15. Defendant number 5 has trespassed into the open area within the boundary of the said premises, taken illegal control and possession thereof, wrongfully and illegally claiming to be a tenant in the open area under the landlord plaintiff 3, and started depositing rent with the rent controller, describing this as an area, as an open shop room. Plaintiff 3 has never accepted or recognized the defendant number 5's possession of the said open area on the northern side. Defendant 5 has no right title interest. Defendant 5, paragraph 17, my lord, has unauthorizedly erected a wall in front of the door at the roadside entrance of the demised premises on the northern side. By erecting a wall, the defendant number 2 has taken control of the pink hatched area. Wall is illegal and is unauthorized structure. Then paragraph 18, a tenant was a tenant in the room over a portion of roof above. So this is again defendant number 1, 2, 3, and 4, not defendant number 5. Kindly see paragraph 21 over the page, my lord. The rest are with regard to the different defendants. The defendant number 5 is in wrongful occupation. Kindly mark this, my lord. Wrongful occupation of the area and has received.
Para 21.
Para 21.
Yes.
Of the area and has received and or with ordinary diligence would have received mean profits reasonably assessed at 30,000. And then kindly take up the cause of action, my lord, paragraph 26, very, very important. So what is the cause of action for filing the plaint?
Yes.
That's paragraph 26. The plaintiff's cause of action against the defendant numbers 1, 2, 3, and 4 for obstructing the plaintiff's free ingress and egress from the southern side arose in 2006. The plaintiff's cause of action against defendant number 5, that's my predecessor in interest, arose on May 10, 2006, when the plaintiff, by a letter, called upon the defendant forthwith to remove the obstruction. Kindly mark this.
That is paragraphs 25.
26 minutes.
Yes.
26, the third line, second line, my lord.
No, page 66.
My lord, page 9 of the plaint.
Page 9.
My lord, of the plaint. Well, I'm indicating from the plaint.
Yes, page 9. No,
Page 9, paragraph 26.
No, no, in the petition.
The plaintiffs.
No, plaint is in page, running page?
9, my lord.
Running page 9.
Running page 9.
Yes, this is petition.
Plaint is separate. my lord.
Yes, give the petition.
I apologize, my lord. I thought your lordship has the plaint with your lordship. It's a separate, my lord, separately kept.
Issue is either the.
Short issue is, my lord, I'll indicate short issue.
Either he was a
I'm sure
tenant
my
or
learned
he
friend
was
will
a
not
trespasser
infringe
or
upon
he
my
was a
submission. He will have his
Let him
chance.
justify. Short, long, what is the issue?
Bosh, please don't say that. Don't.
Orderটা নিলি
Don't, please.
Yes, paragraph.
Losing your temper. But paragraph
9.
26, my lord.
Paragraph 26. Yes.
The plaintiff's cause of action against the defendant numbers 1, 2, 3, and 4 for obstructing the plaintiff's free ingress and egress from the southern side arose on this. So this is not us, my lord. D1 to 4 is not us. The plaintiff number 1's cause of action against the defendant number 5 arose on May 10, 2006, when the plaintiff number 1, by a letter of 10th May 2006, called upon the defendant number 5 to forthwith remove, my lord, kindly mark this part, remove all obstruction to the free ingress and egress from the northern side road entrance, northern roadside entrance to the demised area, and yet the defendant number 5 has failed and or neglected to do so. So this is the cause of action, my lord, against defendant number 5. The next line, my lord, is for 6, 7, and 8. Thereafter, my lord, the next line, defendant number 5, by depositing monies as and by way of rent with the rent controller, has admitted the plaintiff's right title and interest in the pink hatched area and not by limitation,
It is
valuation.
the case of the defendant that they are the tenants of the suit property. It is the case of the defendant number 5.
It's the case of the defendant number 5.
In your written statement, probably.
In our written statement.
That is the case of the
My lord,
defendant
my
number
lord,
5.
that is the case. Now, my lord, whether in this situation, how, my lord, I am protected by law, because they have to follow due process of law for evicting a tenant. What is that due process of law falls for consideration by your lordship? And there are two issues, my lord. The first issue is whether they could have at all filed this, because this issue has been decided once, and I'll show that first. My lord, kindly take up. So this is, my lord, the premise for the plaint, for the suit.
This D is recovery of harsh possession.
My lord. Decree for recovery of khas and vacant possession of this pink hatched area in the northern side. Rest of it, my lord, is injunctions and mean profits and the decree.
Yes.
So, my lord, this is the premise in which the suit was filed, the plaint was filed. The cause of action is very clear against the defendant number 5, that we were stopping ingress and egress, and you were depositing the rent with the rent controller. This you can't do. You can't stop the ingress and egress. And that is what gave rise to the cause of action. So that is the premise of the suit. My lord, kindly take up, and I'll come to what they have stated in their Order 12 Rule 6, which is completely different. Due process of law, my lord, is indicated in the plaint.
Due process of law means filing the suit.
Filing the suit. I'm very grateful.
What can be a better process of law?
On what premise?
That's
Today,
a different issue.
That is an issue which falls
Whether
for
the
consideration.
suit will succeed or not, that's a different issue.
I'm very grateful, my lord.
But you see, there cannot be a better process than filing a
Indeed,
case before the
court.
court.
My case, my lord. Why I'm emphasizing on this is, my lord, they have filed a suit. The suit will be, my lord, it will be tried by the honorable
Whether
court,
either the suit
and
will
then
fail
it will
or
be decreed or it will be, my lord,
suit will
rejected.
succeed.
I'm very grateful. My lord, here the point which I'm seeking to urge before your lordship is, my lord, under what premise are they now moving the Order 12 Rule 6?
Yes.
Order 12 Rule 6, my lord, they are now limiting, my lord, to an operation of law under the West Bengal Premises Tenancy Act. This does not find mention in the plaint. The plaint was not filed either because of necessary requirement or, my lord, the other provisions which are available to them. That's a they have not given any notice for reasonable requirement or for any other, my lord.
Question is, it is the plaintiff's case that you are a trespasser.
That's the plaintiff's case.
Plaintiff's case, very well.
Our case is we are not a trespasser.
No, your case is you are a tenant.
Our case is we are tenant.
Yes.
But now kindly see.
So both have to establish. Now the question is, both have to establish. Now the question is whether the plaintiff has made up a case with regard to judgment on admission.
Judgment on admission.
That is the thing.
Now, my lord, kindly take up page 57. This is the injunction that they have filed. I'll only indicate the prayers which they have made in this petition. Not trouble your lordship for long. My lord, kindly see page 69.
Yes.
First, my lord, A, receiver or special officer to be appointed. I'm not troubling your lordship with 1 to 5. B is injunction. Then mandatory injunction over the page, my lord. C, D, mandatory injunction. T is for us. Then injunction is E, F, G, H. So they have prayed for injunctions here, my lord. With this, my lord, kindly take up the order at page 107. Minutes. This is where, my lord, the injunction petition was being decided by the honorable court. There's few things which I have to indicate from this, my lord, order. Lordship will kindly take up page 108. Submissions of the plaintiffs are recorded. Kindly take page 110.
Yes.
The second paragraph, my lord. The plaintiffs submit that if access is given to the plaintiffs to the eastern portion of the building from the southern side, the plaintiffs would not immediately insist on being given access to the northern side. That's my lord, the grievance with the northern side for defendant number 5. That is through the wall constructed by the fifth defendant in the food stall or tea shop run by the fifth defendant on the northeast corner of the premises. The 3 applications for rejection of the plaint being GA 2219, 2218, 2351 are dismissed without any order as to costs. The plaintiff's application being GA 1704 is allowed in part, confirming the earlier order by which the rolling shutter on the eastern side of the premises was directed to be removed, and by confirming the appointment of the receiver who had earlier been appointed as a special officer. Receiver will remain in symbolic possession of the entire portion of the premises in red ink in the sketch map and will take steps to have the garbage removed from the open area without disturbing the occupation of D7 and D8. The reinforcement of the construction over the garbage dump will be carried out upon notice to the plaintiffs. Now, my lord, kindly take up. So this is how, my lord, partly it was allowed and partly it was rejected. Kindly take up. My lord, page 75 once. My lord, may I only indicate, I'll instead of troubling your lordship now, it's almost 3:30, so your lordship will be taking up the other matter. My lord, I need only one day, any day that suits your lordship. I'll complete any one day, my lord.
Once he is continuing.
ওই আর একটা ম্যাটার আছে, ওটার কি বোথ সাইডস প্রেজেন্ট আছে? তাহলে আমরা কন্টিনিউ করব। ওইটা কত নম্বর আইটেম? নেক্সট না 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 উইটনেস
very very well, very well. My lord, may I only indicate
yes, 42 both parties are present. 42. No, you are for the defendant. So Mr. Mitro is for the plaintiff.
He is not present.
So you may call him. I'll take it up at 3:30. No. I was about to take up. Both sides were not present. That is why I took up this matter. So if Mr. Mitro comes, I'll take up that matter. So today is fixed for cross-examination. Anyway, at 3:30 I'll take it up.
My lord, but may I only indicate one document? Because I have 5 minutes left, my lord. But this is the most important document. But kindly take up page 114. Page 114, my lord. May I kindly see who is affirming this? Page 116, the first line. I, Anit Kumar Jalan, son of so and so, and a director of the subtenant company being plaintiff number 1 herein under plaintiff number 2. He is affirming the affidavit. Kindly take up directly. My lord, page 125, paragraph 23.
Yes.
My lord, kindly see paragraph 23, Roman 2.
Yes.
Kindly see Roman 1 first. Exempt your plaintiffs or petitioners herein from the necessity of substituting the legal representative of defendant number 5 since deceased, so that judgment may be pronounced against the said defendant, notwithstanding his death, and so that the judgment has the same force and effect as if it has been pronounced before the death of the said defendant number 5 took place. That's one, very important. And number 2, the most important, my lord, pronounce judgment on admission and decree for possession of the open market area. So this has already been prayed for. That's page 75, my lord. Prayed for, decided.
No, this is page 125.
125, paragraph 23.
Yes.
And my lord, can you see the pleadings before that? Paragraph 23, how it starts. In the facts and circumstances of the case, and particularly in view of absence of written statement by D5 for long until his death, made his affidavit in filed in GA 1704 of 2006, and the statements made before the special officer are borne from the report of the special officer referred to in para 3 and 18 herein above, and observations of the Honorable Court that none of the defendants have any interest in the impugned shop room. It is fit and proper, and plaintiffs humbly pray that this court would be pleased to pass inter alia the following orders and directions. One of those prayer is, not pronounce judgment upon admission and decree for possession of the open area marked in pink hat, the same portion, my lord, the same prayer. And aforesaid prayers shall inter alia appear from master summons. That's page 125. Kindly see how it is dealt with by the Honorable Court at page 128. The bull, that's pronounced judgment of admission. Kindly see how it is dealt with at page 128.
Yes.
Third paragraph, my lord. By consent of parties, prayer A of the application for judgment upon admission is taken up for consideration.
So this is this application.
This application.
Yes.
Kindly see the number. My learned friend will say no, but before he says no, my lord, kindly see page 114, CS 136, GA. Kindly see the GA number 932 of 2016.
No.
He will say no.
Which is page 128.
With that, my lord, kindly take up because he says no. So he may take that point.
Which page?
Page 114. Kindly see the cause title. Before he says no, he should check it once. Kindly see page. I'll indicate. I'll indicate. Kindly see page 114. I'm sure he will have his chance.
He
But
obtained
page
the order
11.
from division bench that,
No.
that after filing of WS,
Relax.
order 12 rule 6.
Let him satisfy.
But page 114, the cause title, my lord, GA 932 of 2016. Your lordship has found the number.
Yes.
My lord, CS 138. Kindly see page 128.
Oh,
I'll show my defense. I'll only have to show it for trial.
Yes.
Page 128, GA, kindly see the number, my lord, 932 of 2016, CS 130. So my learned friend says some other matter, not some other matter.
Anyway,
Kindly see how the court deals with this, my lord.
I mean,
My learned friend will have his chance.
Yes, what is the order passed in this
Kindly see
application?
third paragraph. By consent of the parties, prayer A of the application for judgment upon admission is taken up for consideration. One Asha Keshri, my learned friend will not allow me to submit.
Yes.
But one Asha Keshri, wife of Dilip Kumar Roy, alias Milord Dilip Kesari, appears and represented by so-and-so, contended on behalf of the said legal heir that on so-and-so advocate on record of the plaintiff was communicated that so-and-so died on 23rd December 2008. It appears from the record that so-and-so entered appearance in the suit. In spite of repeated opportunities being given, they did not file a written statement. Legal heir did not take any steps in the suit. Under such circumstances, court is inclined to exercise its power under order 22 rule 4 of the CPC. Cannot be any doubt that the original defendant, although entered appearance in the suit, has failed to file written statement. What my learned friend is not still getting, and I'll indicate that, under order 22 rule 4 of the CPC, in such circumstances, this court has a power to exempt the plaintiff from substituting legal heirs.
So that was prayer A.
That was prayer A. Therefore, prayer A of the application for judgment upon admission is allowed. Can you see it is written? And I'll indicate what was prayer B. Now, I'm only indicating this.
Prayer A was allowed.
Prayer A of the application was allowed.
Exemption.
He will permit.
Okay, exemption. Yes, what was prayer B?
I will show from judgments.
Anyway, but this application has nothing to do with the present application.
It has, but I'll indicate.
It's a different issue altogether.
But I'll indicate it has. If my lord, I make a prayer in a petition and the court is silent on that prayer, it means, my lord, there's a bar of constructive res judicata. I'll show
grounds that application was made, not only mere application.
It's not mere application, but I'll indicate
on what
from
grounds
the
it was
judgment
made.
upon admission that this point was taken. They could not have filed a judgment upon admission again. That itself is wrong. They'll have a constructive res judicata bar. I'll indicate that.
Let us see on the next day.
My lord, I will. In next day, I'll also conclude, my lord. I'll try and conclude this.
Appeal was preferred. They have preferred an appeal, obtain an order that after filing WS, after adding heirs as party, order 12 rule 6 be taken up. And that has been taken up pursuant to the leave.
I do not understand, my lord, why my learned friend is so scared when
10 months.
we are making submissions.
Anyway, the council is here, okay? You need not, you need not take up the trouble and be excited. Your council has taken up the responsibility.
The property I can't get in my shop.
So, your council will do the needful.
Your lordship will bear in mind all these arguments which my learned friend is
So
making.
ultimately, you have to file the written notes.
My lord, we have to.
So, my lord, kindly, we will not.
Learned
Your lordship had already given directions for filing written notes.
Once we complete
are
our
present.
Ours for written notes are ready.
Bagh, learned advocate for the defendant opposite party, submits but could not conclude the arguments. Let this matter appear on
Day after tomorrow at the top.
My lord, may I only pray for, my lord, next week, any day, my lord.
Again next week. Then Friday, my lord.
এই 19 তারিখে দেখুন তো কি আছে
19
তারিখ বা
Wednesday.
17 18 19 কি দুটো আর তিনটে সময় ফিক্স আছে
My lord, may I only pray for, my lord, any day starting 23rd, my lord, instead of 19th.
No, my lord, this
I'll get the
matter,
weekend, my lord. That's
my lord, this matter is long pending. Mr. Bagh said he's ready to
you
complete.
want 23rd.
He said he was ready
Your
to complete, but with
23rd
paucity of time.
23rd, 24th, any day that suits your lordship.
So,
23rd.
but you come with your written notes of
With the written
arguments.
We will also.
We'll conclude that.
You are ready with your written notes.
I am ready with my written note. I could have concluded if Mr. Bagh had concluded. He said he's ready to.
I am sure.
Only thing is you have to reply and clarify because
Yes,
no
yes.
new points can be raised in your reply. Only on some points of law and
Law,
clarification.
yes, just the law.
Whatever you have to submit, your written notes will be taken up for
Yes, yes,
consideration.
yes, man.
Along with the judgment and compilation.
Yes, man.
Never completed.
আচ্ছা 23 তারিখে কটার সময় আছে 23 তারিখে
That's Monday, my lord, 23rd.
20th is not convenient to your lordship, my lord, this Friday.
actually Friday second half I take appellate side matters. Sometimes it
First
may be
half-
division bench also.
First half in Friday.
First half also there is some uncertainty because sometimes the
Broken
co-arguments have
benches.
to sit in the division bench.
My lord.
23rd there is any difficulty?
No, my lord, I don't have any.
Kindly fix a time in that case.
23rd that is coming Monday.
Coming Monday, my lord. We'll,
আর
we'll
23 তারিখে
file a
কত
note.
আছে বলুন
2 p.m.
24 তারিখে
24th, if your lordship fixes a time, then.
বাবা 4টে থেকে আছে can you conclude within half an hour then I can keep it on
I will.
23rd
I will.
at
I
4
only
p.m.
get the pointers, my lord. I have to
Then, my
show, my
lord,
lord, it
he
goes
will-
for trial. I
My
need
lord,
to
he
get
will not complete in half an hour. The hearing will again, we'll have to trouble your lordship. Kindly keep it.
Expired.
এই 26 দেখুন তো
24, your lordship.
no no
Kindly-
actually if it remains in the list I can keep it this week also
Yes, kindly keep it this week.
But
No difficulty.
26th, my lord.
সামনে বছর 26
আচ্ছা একটা জিনিস করে দিন তো এই 25 তারিখে এই 23 তারিখে তো এমনি মানে within first 5 matters 7 matters এ তো কিছু নেই 23
The
তারিখে
24th.
okay
20.
I am keeping it on 24th within first 10 matters
Grateful.
no 24th is some
Tuesday.
there is also another difficulty because on that day chamber matters that I can keep it
2
on
p.m.
23rd or 25th
25th, your lordship. 24th, 2 p.m. is also not convenient, my lord.
2 p.m. I have fixed other matters
Then 25th,
May-
2 p.m.
25th এ কোনো fixed matter নেই
25th fixed matter নেই তাহলে
হ্যাঁ?
25th.
দুটো থেকে কোনো fixed matter নেই আচ্ছা লানে আচ্ছা তারপর লিখে let this matter appear by consent of the parties the matter is fixed on 25/6/2025 at 2 p.m.
Grateful. We will conclude that.
I'll also
3
conclude.
p.m. as I have another fixed matter, so try to conclude.
I'll not take more than 20 minutes.
Your lordship will remember, hold Mr. Bagh to his
Yes,
commitment.
Absolutely.
Not more than 20 minutes.
I'll file notes, so I'll
Yes,
not
yes, 2
require.
p.m. on 25th.
Grateful.
I'll be extremely short. I have to only show, my lord, this goes for trial. I'll do that in 20 minutes.
Otherwise, this won't complete during the my life.
My lord, one caveat.
This matter
My lord,
goes in this manner.
that submission comes with one caveat. If my learned friend, my lord, not my learned senior friend, my other learned senior friend, but if he continuously, my lord, tries to, my lord, interrupt, then my lord, maybe that 20 minutes may be out of time, my lord.
Your counsel also knows that, okay? He has taken your care. So why are you?
My lord, is it your lordship's pleasure to direct parties to exchange notes before that so that I can come ready and conclude the argument? Then we don't need.
If you can conclude the oral arguments, written notes of arguments will take few days.
Very well.
And I
I am ready.
I
with
shall
mine.
fix a date for orders or judgment, whatever
Very
it is, and give you 3-4 days time to file the
But we
written
are not
notes.
coming then on that day with the written notes.
No, I'll give you both of you
I'm
the
very
time
deeply-
to
very
file written notes within few days.
So we know exactly what the submissions are, so we
Yes.
can deal with it.
After
Very
conclusion
deeply.
of hearing. 3 days his lordship is saying. Lordship
Because
is very-
after the arguments are over, I will require 3-4 days maximum
Yes.
to
Fine.
submit the written notes.
Yes,
And
fine.
thereafter, I'll deliver the judgment.
Lordship.
But I would take 3 hours if
No,
necessary.
3
Yes,
hours?
Mr. Lordship. Within 3 hours, I would complete it. Nothing raised.
No,
only
no,
only one
well-
issue is here. Either the original person was a tenant, or he was a trespasser, or he was a licensee. In
Well,
all the 3 cases, heirs, the substituted heirs are trespassers. What else remains?
See, your counsel has taken care to submit all these things, okay? The court is aware about this.
The pain is with me.
I'm sure he's not the plaintiff. I'm sure. He's
Mr.
identifying too much.
It is not your personal matter.
Personal matter with you.
No, it's not a personal matter, I think.
It is my
No,
personal.
my lord,
Client
we'll
is
come
not-
back. My lord,
Client is
we'll
not,
let us.
client, no, you're not the plaintiff.
My lord,
I
we'll
am the
come back.
director of plaintiff number 3.
Okay. You
It's
may,
my personal matter. That's the way. There should be an end to it.
If
The
it's
person
my learned
as
friend's
bad as-
personal matter, he cannot appear in this matter.
My lord, we will come back on 25th and conclude your argument. My lordship has been very patient. I would only request.
That's the last. And
I
the
would
best
only
defense,
request
and that's the last and the best argument.
I would only request my learned friend to conclude his argument.
I will, my lord.
My
Definitely.
lordship has been
okay,
very patient.
come at
with us.
2 p.m. because 3 p.m. I fix other matters.
Yes, we will do so. I'm very deeply obliged.
Witness section, item number 42, fixed at 3:30 PM.
দাঁড়াবো কোথায়?
সব করা যায় মাল দিলে সব করা যায়
তোমরা একটা করে chair পিছিয়ে যাও।
সব করা যায় না কি করছো তুমি
চিন্তা করছিস?
আমি 2-3টে নিয়েছি
What is your name?
হ্যাঁ, সুদীপ দাস।
সেম ফ্যামিলি
Spelling?
SUDIP DAS।
তো বেশি কাজ করো
UDID লেখ না
কি করছো কি
লিখুন স্পেলিং
তুমি করছো কি বলছি কি করো কি করো কি করছো তুমি এত কাগজ দিয়েছো কি
আপনি কি প্লেন্টিভে থাকবেন না ডিপেন্ডেন্ট প্লেন্টিভের উইটনেস কত বলতে পারবেন?
Yes,
may I start
Yes.
this is what DW, PW, PW1.
PW1 মধ্যে আছেন কত ধীরে ধীরে বলবেন একটা করে সেন্টেন্স আপনি বলবেন একটা আমি বলবো ইয়েস স্যার
what is the area of 14B RN Mukherjee Road
14B RN মুখার্জি রোডের জায়গাটা কতটা বলুন
6 কাঠা 10 কাঠা 21 স্কোয়ার ফিট 6 কাঠা
6 কাঠাস
10 কাঠা 10 21 স্কোয়ার ফিট
21 স্কোয়ার ফিট RN মুখার্জি রোড
14B RN Mukherjee Road।
14B RN মুখার্জি রোড
have you physically measured the landed area wherein 14B RN Mukherjee Road is standing? Premises number 14 RN Mukherjee Road, 14B RN Mukherjee Road is standing.
আপনি নিজে জায়গাটা মেপেছেন?
B RN Mukherjee Road is standing.
না আমি নিজে জায়গা মাপিনি।
No.
Standing.
The witness understands Bengali.
Yes, my lord. No, I
আমি
have
নিজে
not
জায়গা
measured-
মাপিনি।
No, I have not measured the area myself.
Can you tell what is the area of 16 RN Mukherjee Road?
হলো RN মুখার্জি রোডের জায়গাটা কতটা পরিমাপ কতটা বলতে পারবেন?
পরিমাণ কত?
ওটা দেখে একটু বলতে হবে।
I have to check the documents. I have to check the documents. Better 16. Easy.
would I be incorrect if I say that the area of 16 RN Mukherjee Road is 12 kathas, 5 chitaks and 43 square feet?
আচ্ছা, আমি যদি বলি যে 16 RN মুখার্জি রোডের জায়গার পরিমাণটা হলো 12 কাঠা 5 ছটাক কত তারপর
12 kathas, 5 chitaks, 43 square feet. 43
স্কোয়ার ফিট। আমি যদি বলি
43 square feet.
যে 16 RN মুখার্জি রোডের জায়গাটার পরিমাণ 12 কাঠা 5 ছটাক 43 স্কোয়ার ফিট বর্গফুট, আমি কি ভুল বলছি?
সেটা দেখে বলতে হবে।
I have to check the documents.
দিকটা বার কর। বার করো। Is the total area of 14B RN Mukherjee Road under your possession, under the possession of the plaintiff?
14B RN মুখার্জি রোডের সমস্ত জায়গাটা কি প্লেন্টিফের দখলে আছে?
না, পুরোটা নেই, আমাদের ফার্স্ট ফ্লোর এন্ড বেসমেন্ট।
No, not the entire area is under the control of the plaintiff. Only the first floor and the basement area
16
is under control. Are under the control.
এবার কি বললো?
পুরোটা আমাদের দখলে নেই, বেসমেন্ট এরিয়া আর ফার্স্ট ফ্লোর আমাদের কন্ট্রোলে।
Who is in occupation of the remaining area of 14B RN Mukherjee Road?
14B RN মুখার্জি রোডের বাকি জায়গাটা কারদের দখলে আছে বা কার দখলে আছে?
কো ডিফেন্ডেন্ট যারা আছে তাদের আন্ডার।
It is under the occupation of the co-defendants.
Who are the co-defendants?
Co-defendant কারা?
দেখে বলতে হবে।
I have to check the documents.
Can you take the plaint and indicate who are the co-defendants in the present suit? Plaint দাও। আমার দিকটা দাও। Can you name who are the co-defendants in the present suit?
Can you check the plaint?
Certified copy আছে প্লেন্টের, দেখুন একটা।
Shown the plaint করো, ঠিক আছে স্যার? এটা দেখে না co-defendant-এর নামগুলো বলুন।
শ্যাম ইঞ্জিনিয়ারিং এন্টারপ্রাইজেস প্রাইভেট লিমিটেড 2 নম্বর।
শ্যাম ইঞ্জিনিয়ারিং এন্টারপ্রাইজেস প্রাইভেট লিমিটেড, SAM শ্যাম। বলুন।
বিঘ্নেশ্বরা ট্রাভেলস প্রাইভেট লিমিটেড।
বিঘ্নেশ্বরা ট্রাভেলস প্রাইভেট লিমিটেড, পরে দেখে নিস।
বলিষ্ঠ ইটেক প্রাইভেট লিমিটেড।
বলিষ্ঠ ইটেক প্রাইভেট লিমিটেড।
কাকা আয়রন অ্যান্ড স্টিল কোম্পানি।
কাকা আয়রন অ্যান্ড স্টিল কোম্পানি।
দেখাচ্ছে
কজন?
এটাতে এখানে কজন? 5 নম্বর রয়েছে, সিরিয়াল নম্বর 5 অব্দি আছে।
আছে তো 6-7 নেই আপনার
এখানে দেখাচ্ছে না, এটাতে সরি 6 আছে, এখানে পেয়েছি। জ্যোতি মোটর স্টোর্স এন্ড BS ইঞ্জিনিয়ারিং।
জ্যোতি মোটর স্টোর্স এন্ড BS ইঞ্জিনিয়ারিং। BS ইঞ্জিনিয়ারিং।
What is the connection between the plaintiff and the pro forma defendant numbers 1 to 7?
প্লেন্টিফ এবং এই ডিফেন্ডেন্ট নাম্বার 1 to 7 দের মধ্যে কানেকশন কি?
Pro forma
ডিফেন্ডেন্ট নাম্বার 1 to 7 দের মধ্যে যোগাযোগ কি? কিভাবে জড়িত এরা?
14B RN মুখার্জি সব co-owner.
All of them are the co-owners of 14B RN Mukherjee Road.
Are they group companies? আচ্ছা, আস্তে আস্তে বলছি।
তার ওরা কি গ্রুপ কোম্পানি কোনো?
না।
Are they group companies? The answer is no.
Have the pro forma defendant numbers 1 to 5, 1 to 7 filed any proceedings against the defendant in the suit?
Pro forma defendant number 1 থেকে 7 এরা কি ডিফেন্ডেন্ট
2 থেকে 7
2 থেকে 7 এরা কি
7 হবে।
ডিফেন্ডেন্টের এগেইনস্টে কোনো মামলা করেছেন?
ডিফেন্ডেন্ট নাম্বার 1 এর এগেইনস্টে
1 এর এগেইনস্টে?
না।
নো।
Can you tell the court who are defendant numbers 8 to 23.
ডিফেন্ডেন্ট নাম্বার 8 থেকে 23 কারা?
Mention in the plaint.
প্লেন্টে যেরকম লেখা আছে ডিফেন্ডেন্ট নাম্বার 8 থেকে 23 কারা আপনি বলতে পারবেন?
They families.
দে ফ্যামিলি।
Who is they family?
দে ফ্যামিলি লেখো।
DEY, they family.
দে ফ্যামিলি কারা?
Who is they family?
They family.
And why have you made them parties in the present suit?
এবং আপনি কেন তাদেরকে এই মামলায় একটা পার্টি করেছেন?
Who is they family? And why have you made them parties in the present suit?
They family 16 কে যে ল্যান্ডটা বেঁচেছিল 16 আর
দে ফ্যামিলি ইজ দ্য ফ্যামিলি হু সোল্ড দ্য প্রপার্টি
16 আর মুখার্জি
টু 16 আর.এন. মুখার্জি রোড।
কি বলছেন ঠিক করে বলুন। ঠিক করে বলুন। সেন্টেন্স কোড আমি তো আস্তে আস্তে বলছি, আমি তো চেঁচামেচিও করছি। বাংলায় বলুন না, দে ফ্যামিলি কি করেছিল? দে ফ্যামিলি কারা? তাদেরকে পার্টি করেছেন কেন সুটে?
না অতীন্দ্র যখন টোটাল প্রপার্টিটা ছিল দে ফ্যামিলি।
The whole property.
The entirety of the property belong to the Day family.
The entirety of the property belong to the Day family.
হ্যাঁ মানে দে ফ্যামিলি পার্ট করে যে 16 আর মুখার্জিকে যে প্লাস বেঁচেছিলেন সেই জন্য ভবেশ মজুমদারকে।
আমি আপনাদের তো কোয়েশ্চেনটা বলতে পারবো না, আপনি ভালো বাংলায় গুছিয়ে বলুন। আমি তো আপনাকে কোনো চেঁচামেচি বা বকাবকি কিছু করছি না,
ঠিক আছে
আপনি গুছিয়ে বলুন, কিছু যাচ্ছে না কিন্তু।
প্রশ্নটা হচ্ছে দে ফ্যামিলি কে এবং তারা
বললে তো কিছু করেন।
No, first part has gone.
হ্যাঁ বলুন কি দিদি কি বলেছে বলুন তো, আমি বলে দিই বাংলায়। রাজা ঠিক
Yes,
করে।
what was the first portion?
Who are the members of their family? Questionটা হবে who are the members of their family and why have you made them parties in the present suit?
why have you made them parties in the present suit?
আচ্ছা এর থেকে আসতে কি করে?
Yes, whether he has understood.
দে ফ্যামিলি কারা আর তাদের আপনি সুটে পার্টি করেছেন
কেন দে ফ্যামিলির প্রপার্টি 16 কে বেঁচেছিল ভবেশ মজুমদারকে, সেই 16 আর মুখার্জি ভবেশ
বাংলা কথা হলো 16 কে বেঁচেছিল, পরিষ্কার করে বলতে 16 কে বেঁচেছিল
মানে ভবেশ মজুমদার যে
পরিষ্কার করে আমাকে ঝগড়া করছেন, পরিষ্কার করে বলুন না যেটা বলে 16 কে বেঁচেছিল।
ভবেশ মজুমদার 16 আর মুখার্জি রোডের যিনি
16 কে বেঁচেছিল, এটা কোনো যুক্তি হলো?
দে ফ্যামিলি কাকে বিক্রি করেছিল? ভবেশ
ভবেশ
মজুমদারকে। দে ফ্যামিলি sold the 16 আর.এন. মুখার্জি রোড property to Mr. ভবেশ মজুমদার।
এইটুকু
ঠিক আছে
পরিষ্কার করে বললেই হলো।
আচ্ছা আপনি এবার বলুন এদেরকে পার্টি করেছেন কেন?
কোথা থেকে এলি এখন?
এটা একটু দেখে বলতে হবে।
পরের প্রশ্ন উত্তর দিন, কেন পার্টি করেছেন?
কারণ এটা টোটাল প্রপার্টিটা ছিল 14B and 16, এটা অতীন্দ্ররই মানে দে ফ্যামিলির মধ্যেই ছিল প্রথমে, সেই জন্য এটাকে পার্টি করা হয়েছে। এখানে ডিমার্কেশন
Yes, let that go. Let that be recorded.
Entire property of 14B and 16 R.N. Mukherjee Road belong to the Day family. That is why they have been made a party in this current. The entire property of 14B and 16 R.N. Mukherjee Road belong to the Day family. That is why they have been made a party in this current proceedings.
I would not be incorrect if I say that both the plaintiff and the defendant number 1 had purchased 14B R.N. Mukherjee Road and 16 R.N. Mukherjee Road from the members of the Day family.
আমি যদি এটা বলি যে প্লেন্টিফ এবং ডিফেন্ডেন্ট নাম্বার 1 14B এবং 16 আর.এন. মুখার্জি রোড দে ফ্যামিলির লোক দে পরিবারের লোকজনের কাছ থেকে কিনেছেন, আমি কি ভুল বলছি?
না 14B আর.এন. মুখার্জি রোডের মানে আমাদের পোর্শনটা ইন্ডিয়া মোটর পাসের পোর্শনটা আমরা দে থেকে
It is your suggestion, okay? You are suggesting him.
No, I'm asking a question. I'll not be incorrect if I say the property has been purchased from
Either
their
it has
family.
to be a question or in the form of a suggestion.
বললো কি বল কিছু তো বলছি না that is
So if it is your
আরে কেটে দিন
suggestion,
আমি অন্য ভাবি দিলে কেটে দিন বুঝতে পারছি না প্রবলেম হচ্ছে
লাও বুঝতে পারছি
আচ্ছা
প্রশ্ন করছে কি এতগুলো প্রশ্ন করছে দেবনাথদের টেক আ ব্রেথ আমাদের লেভেলে এসব ভালো করে শুনুন উইড আই বি কারেক্ট না বলে এরা স্ট্রেট প্রশ্নটা করো শেক্সপিয়ারে না গিয়ে রবীন্দ্রনাথে নেমে এসো
the plaintiff had purchased portion of 14B RN Mukherjee Road from the Day family. Is that so?
প্লেন্টিফ দে ফ্যামিলির কাছ থেকে 14B আরএন
Portion of
আরএন মুখার্জি প্রপার্টির একটা অংশ কিনেছিলেন ঠিক
একটা পোর্শন কেনা হয়েছে
ইয়েস
the defendant Bhavesh Mojumdar has also purchased 16 RN Mukherjee Road from the Day family, members of Day family. Is that so?
ডিফেন্ডেন্ট ভবেশ মজুমদারও 16 আরএন মুখার্জি রোডের প্রপার্টির অংশ কিনেছিলেন দে ফ্যামিলির লোকজনের কাছ থেকে ঠিক ইয়েস
Is there any physical demarcation between 14B and 16 RN Mukherjee Road?
না কোনো ফিজিক্যাল ডিমার্কেশন
বুঝতে পেরেছেন আপনি প্রশ্নটা নো দেয়ার ওয়াজ নো ফিজিক্যাল ডিমার্কেশন বিটুইন 14B এন্ড 16 আরএন মুখার্জি রোড
চেষ্টা করছি তো না কি বলছো
আনসার ইজ নো
দেখে না একবার যদি হয়ে যায় বলিস বারণ করে দিস অনেকদিন বাদে হচ্ছে তো ভুল হতেও পারে হতেও পারে Does the plaintiff have any access to the open space situated between 14B and 16 RN Mukherjee Road?
14B আরএন মুখার্জি রোড এবং 16 আরএন মুখার্জি রোডের মাঝখানে যে ওপেন স্পেসটা আছে প্লেন্টিফ কি সেই জায়গাটা ব্যবহার করে
যেতে পারে যেতে
হ্যাঁ আমরা ইউজ যেতে পারি
yes we can access the open space
How can you access the open space? Is there a door abutting to the said open space?
হ্যাঁ ডোর আছে আমাদের
yes there is a door
How do you access the open space, কি বলেছিলাম Is there a door abutting to the open space lying between 16 and 14B RN Mukherjee Road?
হ্যাঁ ডোর আছে আমাদের ওখান থেকে আমরা অ্যাক্সেস করব
yes there is a door through which we access the open space between 14B and 16 Iron Mukherjee Road.
What is the area of the open space situated between 14B and 16 RN Mukherjee Road?
এই যে ওপেন স্পেস আছে বলছেন এই ওপেন স্পেসটার পরিমাণ কতটা জায়গাটার পরিমাণ কতটা
এটা এটা আমি আগে অ্যানসার একবার দিয়েছিলাম
কি বলছিস
আগে একবার অ্যানসার দিয়েছিলাম
এখন বলুন পরিমাণ কতটা
অ্যাপ্রক্স লেন্থ আছে ওটা 20 ফিটের মতো
আমি ভুলে গেছি অনেকদিন আগে ছিল তো
20 ফিটের মতন ছিল লেন্থ এন্ড চওড়াটা ছিল 10 ফিটের মতো
the length of the area is approximately 20 feet and the breadth of the area is 10 feet approximately 10 feet
সাইড প্ল্যানটা মনে আছে ঠিক করা আছে হ্যাঁ যেটা করেছি ছেড়ে দিচ্ছি
নামগুলো ভুলিয়েছে
ব্যাস এতদিন বাদে হয়েছে খেয়েই হারিয়ে গেছে না লাইনে দিকটা পেয়েছো আমারটা আমার চাকরি দিয়ে করা উঠলে ছেড়ে
অসুবিধা হচ্ছে না, টেনে দেবো।
প্লেনটা দাও। হ্যাঁ, এটা সার্টিফাইড কপিটা প্লেনটা দিন তো ওনার। সার্টিফাইড কপি এসছে আমার।
ঠিক আছে দাদা।
Who is Pine Properties?
স্যার আরেকবার।
Who is Pine Properties as
Sorry?
mentioned in paragraph 2 of the plaint?
প্লেন্টের প্যারাগ্রাফ 2 এ পাইন প্রপার্টিস এর
আপনি
উল্লেখ
দেখে
আছে। পাইন প্রপার্টিস কে বা কারা?
এক মিনিট একটু দেখে নিচ্ছি।
গোয়িং থ্রু দ্য প্লেন্ট।
পেজ নাম্বারটা কোথায়?
প্যারাগ্রাফ 2 বলেছেন। প্যারাগ্রাফ 2 অফ প্লেন্ট।
পাইন প্রপার্টিজ প্রপার্টিটা অতীন্দ্র প্রাইভেট লিমিটেড কে বেচেছিল 14/5/1978 এ।
1978
পাইন প্রপার্টিস ইজ দ্য পার্টি হু সোল্ড দ্য, কোন প্রপার্টিটা বিক্রি করেছিল বলুন? আপনি যে বললেন না প্রপার্টিটা বেচেছিল, কোন প্রপার্টিটা বেচেছিল?
14B।
Pine Properties is the party who sold the 14B RN Mukherjee Road property to Otindro Private Limited on 14th March 1978.
Who is Golden Trust?
Golden Trust কে?
এটা হয়ে গেছে, জিজ্ঞেস করা হয়ে গেছে, নোট আছে, সেটা জিজ্ঞেস করা হয়ে গেছে, যেটা হয়ে গেছে করবো না, লেখা আছে, ঠিক দেওয়া আছে। না চলবে, শেষ এত তাড়াতাড়ি হবে। Do you, the open space which you are referring at present is used by the plaintiff or the defendant number 1?
আপনি যে ওপেন স্পেসটার কথা বলছেন, সেই ওপেন স্পেসটা বর্তমানে কাদের দ্বারা ব্যবহার করা হয়? প্লেন্টিফের দ্বারা না ডিফেন্ডেন্টের দ্বারা?
হ্যাঁ, আমরা ইউজ করি।
আপনারা কারা? প্লেন্টিফ।
প্লেন্টিফ।
The open space is currently used by the plaintiffs.
How do you use this said open space?
কিভাবে ইউজ করেন এই ওপেন স্পেসটা?
আমরা ডোর দিয়ে নর্মাল পেজ দিয়ে যেরকম যাতায়াত করি ওরকম ব্যাস জাস্ট ভিজিট করার জন্য।
For ingress and egress we
Just
use
visit
the
করার জন্য।
open space.
Visit the same, visit করা।
ভিজিট করার
What is the
Visit the
purpose
same.
of your such visit?
এই ভিজিটের পারপাস কি? কি উদ্দেশ্যে ভিজিট করেন?
কেন 16 RN মুখার্জি রোড যে RN মেটাল স্টেয়ারকেসটা ওখানে ইলিগালি ওটা করেছে আমাদের 14B RN মুখার্জির জমির উপরে।
কি বলছেন? আস্তে আস্তে বলুন।
ওপেন স্পেসের উপরে যে আয়রন মেটাল স্টেয়ারকেসটা কনস্ট্রাক্ট করেছিলেন 16 RN মুখার্জি রোড মিস্টার ভবেশ মজুমদার, সেটাকে আমরা ওখানে গিয়ে একটু দেখি যে ওটা কি ফার্দার আবার কনস্ট্রাকশন হচ্ছে কি হচ্ছে না সেগুলো চেক করার জন্য আমরা যাই ওখানে ভিজিট করি।
ভবেশ মজুমদার constructed a metal staircase in the property of 16 RN Mukherjee Road.
No, the property of 14B RN মুখার্জি রোড।
কোথায় বলেছেন? কি
Property of 14B. This open space belongs
আপনি
to
আস্তে আস্তে বলুন স্যার, আস্তে আস্তে বলুন।
বলুন, আস্তে আস্তে বলুন।
বলুন।
ওপেন স্পেস যেটা রয়েছে এটা 14B RN মুখার্জি রোডের আন্ডারে আসে, এটা আমাদের আন্ডারে।
The open space belongs to 14 RN Mukherjee Road. 14B RN Mukherjee Road belongs to the plaintiff.
হ্যাঁ।
Okay.
কি হচ্ছে? Belongs to 14 RN Mukherjee Road.
14B RN মুখার্জি রোড।
14B RN Mukherjee Road কি?
প্রিমিসেস এর আন্ডারে পড়ে ওটা।
কোনটা?
যে আয়রন মেটাল স্টেয়ারকেসটা যেটা
Yes, put the question once again.
Metal.
Yes, I put the question once more.
Just
clarify the
আচ্ছা
question.
সন্দীপ দা প্রশ্নটা বলে দিন তো একবার, আপনি তো লিখেছেন তো দিদি বলে দিন। বলতে দে, আমি তো আর কি চোখে দিয়ে দেখাচ্ছি না।
Yes, please.
What is the purpose of your such visit to the open space situated between 14B RN Mukherjee Road and 16 RN Mukherjee Road?
অল্প অল্প করে ছোট ছোট করে বলুন, পরিষ্কার বাংলায় পুরো সেন্টেন্স।
And why do you visit that open space?
Visit, open space.
যে ওপেন স্পেসটা রয়েছে ওটা আমরা ভিজিট করতে কেন যাই, যে এখানে আয়রন মেটাল স্টেয়ারকেস যেটা কনস্ট্রাক্ট করেছে 16 RN মুখার্জি রোড, মিস্টার ভবেশ মজুমদার।
We visit the open space to see the iron metal staircase which was made by 16 RN Mukherjee Road, Mr. Bhavesh Mujumdar.
ওই জায়গাটা 14B RN মুখার্জি।
Slowly.
Which was made constructed by Bhavesh Mujumdar.
Bhavesh Mujumdar. বলুন, which
ওই স্পেসটা আমাদের 14B RN মুখার্জির আন্ডারে পড়ে।
that space belongs to 14B RN Mukherjee Road.
সেই জন্য ফার্দার ওটা কনস্ট্রাক্ট হচ্ছে, কোনো কিছু ডেভেলপমেন্ট হচ্ছে কিনা কনস্ট্রাকশন, যেটা ভিজিট করার
We
জন্য আমরা
visit that open space to see whether there is any further development of that construction or not.
When such construction of iron staircase took place on the open space, on the said open space, কবে iron
এই যে আপনি যে আয়রন স্পেসটার কথা বলছেন, এই কনস্ট্রাকশনটা ওপেন স্পেসে কবে হয়েছিল?
এটা ইয়ার অফ 2011 এ হয়েছিল।
In the year 2011,
স্টার্ট হয়েছিল।
the construction was started in the year 2011.
When did you join the plaintiff company? Plaintiff, when did you join the
plaintiff company?
2005.
In the year 2005, I joined the plaintiff.
Did you file any police complaint against Bhavesh Mujumdar?
আপনি কি ভবেশ মজুমদারের বিরুদ্ধে
for constructing the iron staircase on the open space?
ভবেশ মজুমদারের বিরুদ্ধে কি এই আয়রন মেটাল স্টেয়ারকেস তৈরি নির্মাণের জন্য আপনি কোনো পুলিশ কমপ্লেন করেছিলেন?
যতদূর জানি ইনজেকশন জারি হয়েছিল এইসব।
As far I know, there was an injection.
Injunction জারি হয়েছিল।
Have you produced any order of injunction in the present proceedings?
আপনি কি এই মামলায় এসে ইনজাংশনের কোনো কপি বা কিছু দাখিল করেছেন?
সেটা দেখতে হবে, আমি কি বলতে পারবো।
I have to check the documents.
Have you initiated? You have not answered my question. Did you file any police case complaint against Bhavesh Mujumdar for making construction of for installing a staircase in the open space?
আপনি কি ভবেশ মজুমদার
আমার কোম্পানি এই সময় কিছু করেছিল কিনা সেটা দেখতে হবে, ওটা
I have to check whether my company took any step or not at that point of time. বলুন।
না বিষয়ে যারা
Whether the company lodged any complaint before the police or not?
হ্যাঁ ম্যাডাম, তো
Lodged any complaint to the police?
Is there a water reservoir situated in the open space, in the said open space?
Open space কি কোনো
হ্যাঁ ওয়াটার রিজার্ভার আছে।
Yes, there is a water reservoir.
Who draws water from the said water reservoir?
এই রিজার্ভার থেকে
Lying in the said lying in the said open space?
ওপেন স্পেসে যে ওয়াটার রিজার্ভার আছে সেখান থেকে জল কারা নেয়?
16 RN মুখার্জি রোডে যায় প্রিমিসেসে।
16 RN
এটা আমরা অলরেডি অবজেক্ট করেছিলাম।
16 RN Mukherjee
কি
Road.
নেয়?
Water from this water reservoir to which we have objected.
How you have objected?
কিভাবে
By way of contemporaneous documents?
কিভাবে আপনার অবজেকশন জানিয়েছিলেন?
না এই শুটের মধ্যে রয়েছে।
How you have objected? By way of any contemporaneous documents? মানে চিঠিপত্র দিয়ে অবজেক্ট করেছেন?
না না ওরকম
No.
Is there any pump room on the said open space?
হ্যাঁ
স্পেসে কোনো পাম্প রুম আছে? Yes.
Who operates this?
মানে পাম্প রুম আছে, সরি।
Yes, there is a pump room.
Who operates the said pump room?
পাম্প রুমটা কে অপারেট করে?
16
16
16 RN মুখার্জি
পুরোটা
16 RN মুখার্জি রোড
16 RN মুখার্জি
কারা করে মানে 16 তো
16
একটা
RN
বাড়ি
মুখার্জি,
কি করে
হ্যাঁ,
অপারেট করে বলুন
বলছে না 16 এর লোকেরা বলছে
RN মুখার্জি রোড
16 তো মানুষ নয়।
ও রাজা বলে দাও
রাজা কি ডকে উঠবে এবার, বলে রাজা বলে দাও।
আমি তো বলতে পারবো না তোমার তুমি বলে দাও কি বলে 16 তো একটা বাড়ি কি করে জল from the occupiers by the occupiers of 16
Of
RN
16
Mukherjee.
RN
মুখার্জি রোড, ইয়েস। ইয়ে নাও ভাই,
তো সন্দীপ দা আছে তো করে দেবে দিদি আছে
ঠিক করে দেবে, তুমি একটু চেক করে দিও ওটা।
রড ভাবছিলাম।
since when the occupiers of 16 RN Mukherjee Road is utilizing the reservoir and the pump room lying in the open space, said open space,
16 RN মুখার্জি রোডের বাসিন্দারা কবে থেকে এই রিজার্ভার এবং পাম্প রুমটা ব্যবহার করে আসছেন?
এটা বলতে পারবো না, এটা দেখতে হবে।
I cannot say that. I have to check the documents.
when you joined the company in the year 2005, the members, the occupiers of 16 RN Mukherjee Road were utilizing the reservoir and the operating the pump room. Is that so?
আপনি 2005 সালে যখন প্লেনটিফকে জয়েন করেন তখন কি 16 RN মুখার্জি রোডের বাসিন্দারা এই রিজার্ভার এবং পাম্প রুম ব্যবহার করছিলেন?
না, তখন তো আমার ওই অথরিটি ছিল না পেছন দিকে যাওয়ার।
No, at that point of time, I did not have the authority to go to the backside.
Who gave you the authority to go to the backside?
কে আপনাকে অথরিটি দিল পিছন দিকে যাওয়ার জন্য?
না, তখন কোম্পানিতে যারা ছিলেন
কে আপনাকে অথরিটি দিল পেছন দিকে যাওয়ার জন্য?
না, আমাদের তখন ম্যানেজার ছিলেন, যিনি
Who is the
ব্রাঞ্চ
manager?
ইনচার্জ ছিলেন ওই
Who is
সময়।
the manager
There
who
was
authorized you
there
to
was
visit
our-
the backspace?
there was
Yes,
a-
first let that go. Branch manager authorized me to
আর
go.
তখন ডেপুটি জেনারেল ম্যানেজার যিনি ব্রাঞ্চের ইনচার্জ ছিলেন আমাদের অফিসে।
উনি আপনাকে অথরিটি দিলেন, তাই তো?
হ্যাঁ।
At that point of time, the deputy manager of our company gave me the authority to visit the backside.
Visit the backside. What do you mean by the backside? The open space?
ওপেন স্পেস।
By the backside, I meant the open space between 14B and 16.
Can you name your assistant general manager who has authorized you to visit the open space situated between 16 and 14B RN Mukherjee Road?
Assistant or deputy?
ডেপুটি
Deputy General Manager নাম বলুন।
মিস্টার আর শিবরামন।
Mr. R. Shivaraman.
Is Mr. R. Sivaraman still with the plaintiff company?
উনি রিটায়ার্ড হয়ে গেছে।
No, he has been retired.
রিটায়ার করে গেছে, যা অথরিটি দিয়ে রিটায়ার।
He is retired. He is retired also.
রিসিভার রিপোর্ট আছে, ওটা অ্যাপয়েন্টেড অফিসার না দেখে
সেটা করবো তো, রিসিভার আসবে তো, ক্রস হবে আসবে তো। জাস্ট রাজা এক মিনিট চেক করে নিচ্ছি একটা কোশ্চেন, স্কেচ ম্যাপ আছে কিনা।
5 মিনিট
উত্তর কি দিয়ে করবো না তাহলে। where from the occupiers of 14B RN Mukherjee Road draw water?
14B RN মুখার্জি রোডের বাসিন্দারা কোথা থেকে জল নেন?
আমাদের 14B আর মুখার্জি প্রিমিসেসের মধ্যে থেকে আমাদের জল।
We draw water from our own premises.
There must be a reservoir and a pump room by which the occupiers of 14B RN Mukherjee Road draws water for their consumption?
14B আরএন মুখার্জি রোডের নিশ্চয়ই একটা রিজার্ভার এবং পাম্প
What do you say
থাকবে
to that?
যেখান থেকে 14B এর বাসিন্দারা জল নেন। right?
আমাদের পুরো বিল্ডিং এ ওইভাবে জল নেই, আমাদের সব ইন্ডিভিজুয়াল যারা ওনার আছে সবার আলাদা আলাদা লাইন করা আছে, রিজার্ভার করা আছে।
Where is the reservoir situated?
স্যার এটা আস্তে আস্তে বলুন এটা।
হ্যাঁ, আমাদের 14B আর মুখার্জি যে যারা ওনার আছে তাদের আলাদা আলাদা সব লাইন আছে, ওয়াটার লাইন।
For the owners of 14B আরএন মুখার্জি রোড, they have all separate water connections, right?
হ্যাঁ,
Okay,
separate.
তারপর বলুন। Separate
Where
water
are the
connections.
reservoirs situated for the purpose of drawing water by the occupants of 14B RN Mukherjee Road? রিজার্ভারটা কোথায়?
জল নেওয়ার জন্য রিজার্ভার গুলো কোথায়?
রিজার্ভার আলাদা করে কারোর কোনো ওনারের নেই, সবাই ইন্ডিভিজুয়ালি বানিয়েছে 14B-র মধ্যেই।
Where?
14B আর মুখার্জির মধ্যে।
There
মানে
are no
আমাদের যেমন 14B ইন্ডিয়া মোটর পার্সে
বল ক্লিপস।
there are
আগে কি
no
বলছে
reserv-
লিখুন।
there are no reservoirs individually in 14B.
না না,
কি বলছে দেখুন।
কমন রিজার্ভার নেই কোনো।
কোনো কমন রিজার্ভার নেই।
Yes, what was your
There is no
question?
common
Where is
reservoir.
the reservoir of 14B RN Mukherjee Road situated?
common
Understood the
reserve-
question?
হ্যাঁ
14B reservoir,
Reservoir
where
টা
it is situated?
হ্যাঁ,
Common
স্যার
reservoir নেই।
কমন রিজার্ভার নেই।
হ্যাঁ।
Okay, okay.
There is
just-
no such common reservoir at 14B RN Mukherjee Road.
So how do you draw water for
আমাদের
your consumption?
আমাদের যেমন ইন্ডিয়া মোটর পার্সের আমাদের যে কনজাম্পশনে আমরা বেসমেন্টে আমাদের যে পোর্শনটা আছে ওখানে ব্যাক সাইডে আমরা ওয়াটার রিজার্ভার আছে, ওখান থেকে আমরা জল নিই।
For India Motor Parks, we took the water from the basement portion reservoir. The reservoir situated at the basement portion
Of 14 RN Mukherjee.
of 14 RN Mukherjee Road.
14B
14B RN.
14B
And where is your pump room?
আর আপনাদের পাম্প রুমটা কোথায় আছে?
আমাদের বেসমেন্টে ওই পাম্পের সাথে পাম্পের আছে, মানে ওয়াটার রিজার্ভের সাথে মেশিন আছে পাম্পের।
And at the basement, we have the pump room with the water reservoir.
No. Kindly take exhibit A of your evidence. Exhibit A টা দিন তো। Being indenture dated 24th June 1983, entered into between Otindo Private Limited and India Motorsports Accessories Limited. Exhibit A,
দেখো না ভাই, তুমি
exhibit এর
দেখো,
file থাকবে।
ওকে দেখাচ্ছি, ওকে দেখাচ্ছি।
স্যার আমরা
exhibit এর ফাইল থাকবে তো আলাদা, সার্টিফাইড কপি দিয়েছিল বোম্বেতে না ম্যাড্রাসে আছে।
তাহলে
এক্সিবিট এ আছে দেখুন, দেখে আমায় দিন একবার। হ্যাঁ এটাই,
না ট্রান্সলেট করতে পারে না, ওই তো এক্সিবিটে লেখা আছে তো,
এই তো exhibit।
ওই তো কোনে লেখা আছে।
Your matter was fixed at 4 o'clock, okay? Just, it will take not more than 10 minutes, your matter.
Let me
Maximum 10
complete
minutes.
this part and give me half an hour and more or less next time more or less I've completed nothing.
No, no, you cannot complete it today.
No. Little bit
Anyway,
on the
put one or
exhibit.
two more questions.
Yes, only that much. It's more or less done. On the sketch map, only thing is written, nothing else.
yes sir. কোন exhibit এ?
Is this the document by which you have purchased the portion by which the plaintiff has purchased its portion from Otindro Private Limited, situated in 14B RN Mukherjee Road?
এটাই কি সেই ডকুমেন্ট যার দ্বারা আপনারা অতীন্দ্র প্রাইভেট লিমিটেড এর কাছ থেকে 14B RN মুখার্জি রোডের একটা অংশ কিনেছিলেন?
হ্যাঁ, অতীন্দ্র থেকে আমরা যে 14B করেছি যে অংশটা আমরা কিনেছিলাম,
এটাই সেই ডকুমেন্টটা, তাই তো? yes, this is the document.
সার্টিফাইড কপি।
This is the certified copy of that.
Where is the original?
অরিজিনালটা কোথায়?
হ্যাঁ, হেড অফিসে আছে।
at our head office.
ঠিক আছে, স্টেটটা থাকবে না, ব্রেক হয়ে গেছে না। Do you find any mention of open space in exhibit A being the deed of indenture dated
24th June 1983.
24th June 1983.
এই ডকুমেন্টে আপনি কি কোথাও ওপেন স্পেস শব্দটার উল্লেখ পাচ্ছেন?
একটু দেখছি দাঁড়া।
I have to check the document.
আমি কিন্তু ওকে কোনো তবরাইনি তাও করছি এরকম। বল।
না, ওপেন স্পেসের কোনো উল্লেখ নেই এখানে ওরকম ওপেন
No,
স্পেস।
there is no mention of
টোটাল যে
আমি আমার
No, there is
প্রশ্ন
no
open
mention
space এর
of-
কোনো উল্লেখ আছে এতে?
of open space in the said document.
Do you find any sketch map or site map in the said deed of indenture?
এই ডকুমেন্টে কোথাও আপনি কোনো ম্যাপ দেখতে পাচ্ছেন? সাইট ম্যাপ, স্কেচ ম্যাপ বা সাইট ম্যাপ দেখতে পাচ্ছেন?
না, এটার মধ্যে নেই।
No.
এই কপিটার মধ্যে নেই।
There is no such sketch map, not in this.
Have you produced any plan sanctioned by Kolkata Municipal Corporation in favor of the plaintiff in relation to 14B RN Mukherjee Road?
চেক করতে হবে এটা
I have
কোনো
to
কিছু
check the
জমা
doc-
হয়েছে কি না দিয়ে।
I have to check the document whether it has been submitted or not.
Can you find the same and disclose this said plan issued by Kolkata Municipal Corporation on the next date of hearing?
আপনি কি প্ল্যানটা খুঁজে বার করে নেক্সট দিন দেখাতে পারবেন?
আমি দেখতে হবে এটা রয়েছে কিনা, সেটা না দেখে তো বলতে পারবো না।
I have to find out the document. I have to check the document. I cannot say anything without searching it out.
14B RN Mukherjee Road must be having a plan duly sanctioned by Kolkata Municipal Corporation. Is that so?
14B RN মুখার্জি রোডে নিশ্চয়ই একটা প্ল্যান থাকবে যেটা কলকাতা মিউনিসিপাল কর্পোরেশন দ্বারা স্যাংশন করা হয়েছে, রাইট?
হুম।
Yes.
And whatever is there in the building must be evident from the said sanction plan.
এবং বিল্ডিং এ যা কিছু আছে সেই স্যাংশন প্ল্যানটা থেকে তা বোঝা যাবে।
হ্যাঁ, সে তো অবশ্যই।
Yes, certainly.
And you will also make attempt to produce the said sanction plan on the next date of hearing.
চেক করতে হবে যে আমার কপি দেখে না দেখে তো বলতে পারবো না।
I have to check it. I cannot
Next
say
all.
without checking.
That's all. Next I have more or less completed. I'll show my sanction plan, confront him and end it.
Learned advocates for the parties are present.
Order pass হলে তারপরে
PW1 is present in court. PW1. Yes, what is the name of PW1?
সুদীপ দাস।
Huh?
সুদীপ দাস।
Yes, PW1 Sudip Dash is present in court. PW1 is further cross-examined and discharged. Let this matter appear on কত তারিখে দেখুন তো, 3:30 সময় কিছু দেওয়া যাবে কিনা, বা 4টের সময়। 24 তারিখে তো কিছু নেই। হ্যাঁ, না 24 তারিখে
24 আসতে পারবেন?
এই ক্যালেন্ডার
25-এ 2 PM নেই, কিন্তু 3 PM আছে 25-এ, আর দুটোর সময় কিছু নেই। আচ্ছা, এখন আজকে যেটা, আজকে তো 25-এ কিছু তার কিছু ফিক্স হয়নি আজকে, তাহলে ওকে, লেট দিস ম্যাটার অ্যাপিয়ার অন 25th. 25/6/2025 at 2 p.m.
Witness will be present.
Yes, let the witness be present on the said date. Yes, you complete on the next day?
I'll complete. They are more or less on the last word.
ঠিক আছে।
Grateful. Grateful.
Arguments. চল্লিশটা ডেকে দিন।
No arguments, item number 40.
Yes, last occasion, the matter was adjourned to ascertain as to whether the citation was issued upon the opposite parties or not, probably.
No, Lord, so far I remember.
So let me see the order of the last occasion.
I directed the department to issue a certificate whether there is no any caveat.
Yes.
That is the last order.
Citation was issued.
It was issued, first citation, second issued, and nobody has appeared and
No, but
contested.
whether there was any caveat or not.
Ah, yes, that is the
Department
report
was
Lord
directed to
has asked the department to produce the report as to whether there is any caveat. I don't know whether the report has come.
Matter 25. ম্যাটারটা লাস্ট কবে হয়েছিল এটা? তুই মেয়ে দেখাচ্ছে সম্ভবত ওই মে মাসে লাস্টের দিকে 21 কিংবা 22-এ
তারিখে লাস্ট কবে হতো? নেক্সট ডে ঠিক
কত 6 মে না, তারপরে তো এই যে দেখুন এইখানে এটা তো 2 তারিখেও রাখা হয়েছিল, তারপরে তো একটা এক্সামিনেশন ইন চিফ হয়েছিল, তারপরে এটা ফর অর্ডার্স ছিল আর কি। না না না, এই তো এই অর্ডার আছে। ডিপার্টমেন্টকে ডাইরেক্ট করা হয়েছিল টু সাবমিট এ রিপোর্ট। You can do one thing, you can take a certificate from the department as to whether any caveat was there or not. দেখুন তো রিপোর্ট দিয়েছে কি? I am also issuing a direction upon the department, you also apply to obtain a certificate as to whether there was caveat or not.
I will, my lord.
Yes, record an order. Mr. Tiwari, learned advocate for the petitioner, is present. In terms of order dated May 21, 2025, no report is submitted by the department as to whether a caveat has been lodged in this case. Let this matter appear on
Give me a short time, I will try to get the report. 2 weeks.
26/6/2008 26 তারিখে 4টের সময় কিছু ম্যাটার আছে। 26/6/2025 26/6/2025
my lord
at 4 p.m. stop. So that I am not recording that you can obtain, that you can obtain a certificate.
Can you give me liberty to apply?
Okay. Petitioner is also granted liberty to obtain necessary certificate from the department as to whether the caveat is lodged or not.
My lord. I am not may the department not issue the certificate if I apply.
No, if you apply, they will definitely issue either yes or no.
Lord.
And I have also called for a report.
Lord.
So 26/6/2025.
I will do that. You know,